Where is our case caller? Ms. Tokozo Sobikwa.
Morning. I am the Register Clerk for this hearing. Justices of the Constitutional Court, all counsels are online. I call the matter of Amabhungane Center for Investigative Journalism and the President of the Republic of South Africa for hearing. Counsels are now invited to place themselves on record. Please note that this hearing is being recorded.
Thanks, Ms. Sobikwa.
As it pleases the court, Justice Madlanga, Justices of the Court, I appear for the applicant in this matter together with my learned friend, Mr. Ramachale.
Thank you, Mr. Badlenda.
Justice Madlanga, members of the court, I appear.
Mr. Wilson, don't you have two devices there?
There may well be. Will you turn your... Does that improve?
Yes,
sound?
It sounds like yes.
I shall take it up with Mr. Salukazana later. I appear together with Mr. Salukazana for the Amicus Curiae, the Johannesburg Society of Advocates.
Thank you, Mr. Wilson. Yes, Mr. Badlenda.
Muted. Justice Madlanga, I think Mr. Badlenda.
You would have thought that 2 years into these hearings, I would remember that I need to unmute before I address the court. Thank you very much, and I apologize. Let's try that again, shall I? Justice Madlanga, members of the court, as this court knows, these are confirmation proceedings arising out of the declaration of invalidity granted by the full bench of the Pretoria High Court regarding the Executive Ethics Code and concerning the question of whether there is sufficient duty of disclosure in respect of donations made to internal party campaigns. It appears common cause, and it seems with respect undoubtedly correct, that the declaration of the High Court is subject to confirmation by this court, because although regulations are not normally subject to confirmation, the conduct of the president is, and this is conduct of the president, and our learned friends for the amici take the same view. I propose to summarize certain core contentions in the course of this protected time, and then I will deal with 5 issues. Firstly, I will deal with the flaws in the new case sought to be advanced by our learned friends for the amici and explain why their new case doesn't assist. Secondly, I will deal with what the Act required, the Executive Ethics Act required of the Code. Thirdly, I will deal with what the Constitution required of the Code. Fourthly, I will deal with why the Code does not comply with either the Act's requirements or the Constitution's requirements. And finally, I will say a word about the Political Party Funding Act and why it does not change this case. But can I begin by saying that this is a very unusual case? It's an unusual case because it has the benefit of 2 reasoned judgments by this court. And when those 2 reasoned judgments are put together, we submit that the answer is ineluctable, that the Code does not meet the constitutional requirements. The first reasoned judgment of this court is the judgment of this court in My Vote Counts 2. And we have cited that at some length in our heads of argument, and I won't repeat that all. But what My Vote Counts 2 does is it establishes the risk of money in politics and donations in politics. It, of course, does so in the context primarily of donations to political parties, but nothing changes whether money is being donated to the political party or to the individual candidate or in a way that assists the individual candidate. What this court explains in My Vote Counts 2 is that the risk of money in politics is enormous. But more importantly, what this court explains in My Vote Counts 2 is that the way to deal with this risk is to have mandatory disclosure of such donations. And the gist of this court's judgment is to say it's not enough to make it optional, it's not enough to allow workarounds. There has to be mandatory disclosure of such donations for 2 purposes. The first is to enable members of the public to properly and meaningfully exercise their constitutional rights to vote and so on. And the second is to act as a bulwark against corruption. Because as this court explains, it's only when you have a mandatory disclosure that you have some prospect of acting as a bulwark against corruption. So that's the first judgment of this court. The second judgment of this court is this court's judgment in the public protector matter. It makes clear that not all donations to campaigns to elect people for powerful internal party positions will be disclosable. Sometimes they will be, and sometimes they won't be. And what it makes clear is that it is possible for one to structure an internal party campaign in a way that the disclosures will not have to be made. So you create a separate legal entity. You make sure as the member of the executive, the MEC or the minister or the president, that you are not controlling the funds. And therefore, on the approach adopted by this court, understandably in light of the wording of the code, there is no personal benefit and therefore there is no disclosure, even though, and I'll come back to this point, even though you might well be aware of who's been making the donations. Now, when you put those 2 points together, the risk of money in politics, the need for mandatory disclosure and avoiding of loopholes to make sure that there's a bulwark against corruption and the enabling of constitutional rights, that's my vote counts too. And you put that together with this court's judgment in the public protector matter, which held that as a matter of interpretation, this code did not give rise to mandatory disclosure of all such donations. We submit that it's plain then that there is a problem. There is a constitutional problem, there is a problem in light of the Executive Ethics Act, and it is a problem which we submit renders the code unconstitutional to this extent. But were there any doubt, that problem is made clear by the third point. And the third point is the silence of the president. Because we know that this is not a law enacted by Parliament. This is a code enacted by the president, and it was for the president to come and defend the code. And in the first round of litigation before the High Court, the president elected to file many affidavits, but he did not file an affidavit explaining why this code was constitutional. He never sought to explain the approach taken by the code. When this court referred the matter back to the High Court, again, there was an opportunity for the president to decide whether he wanted to file an affidavit. And again, the president did not do so. So this court is left without any explanation on oath from the president. And of course, let me say, I accept it wasn't President Ramaphosa who made this code. It was his predecessor, President Zuma, but that doesn't change anything. As this court knows well, it's for the incumbent to explain the approach. And in this case, there has been no explanation. But it gets even clearer because, of course, the president, having vigorously opposed in round one and having vigorously opposed in round two before the High Court, has now elected to abide the decision of this court. And he's perfectly entitled to do, and no doubt he was advised by the two very, very eminent and senior counsel who were representing him. But he's perfectly entitled to do that, and I do not imply any criticism. But what I do say is that that demonstrates that there is no proper defense of the code available because the president has recognized as much. And with respect, this court should confirm the order of invalidity. Those 3 points we submit, the effect of my vote counts too, the effect of this court's judgment interpreting what the code means and what its limitations are, and the silence of the president and his inability or unwillingness to defend this code, we submit ought to be dispositive of the case, and the code ought to be declared invalid. And of course, let me say, the remedy that we seek is not a reading in, it is not a mandamus, it's not even an interim reading in, it is simply a declaration of invalidity suspended for 12 months, looking forward so that the president can reformulate the code in a way that will deal with this difficulty. So you are not tying his hands, and you are not in any way, with respect, causing any difficulty in that regard. Justice Madlanga, that captures my initial submissions, and I'm happy to waive the rest of my protected time. But in doing so, may I move to begin by discussing the flaws in the amici's argument, because I think that that would elucidate some of the points which I wish to make.
Thank you, Mr. Badlander. Maybe the question I'm going to pose actually does relate to the issues raised by the amicus. Does the Ethics Act require that the code should provide for what Amabhungane say is lacking constitutionally?
Yes.
Is that which is alleged to be lacking constitutionally required by the Ethics Act?
Yes, Justice Madlanga, the answer to your question is yes, particularly when the Ethics Act is read in the light of the Constitution and the Section 7.2 obligation enunciated by this court in Glenister. But might I beg your indulgence, Justice Madlanga, to deal briefly with the flaws in the amici's approach and then turn to the next. My second topic will indeed be what the Ethics Act requires. If I could beg your indulgence briefly to do so. All right,
Mr. Butler.
Thank you. So if I could deal with the flaws in the amici's argument, because it demonstrates, and let me say, our learned friends are in an invidious position in trying to defend an enactment which has not been defended by the president and where there is no evidentiary basis to do it. But with respect, in their attempts to do so, they have committed what we submit are two cardinal flaws and which demonstrate how untenable the defense is. The first flaw is that they have relied extensively on passages of the first High Court judgment, which were expressly overturned by this court. So, for example, in paragraph 55 of our learned friends' heads, our learned friends call in aid the High Court's first judgment at 194.4, which says that we have the wrong target and that the constitutional challenge should be directed at the Ethics Act. And then similarly in paragraph 75, they say that there is a subsidiarity problem because the challenge should have been to PIA. But that argument was squarely rejected by this court in paragraph 141 of its judgment, where the very subsidiarity point that was raised was in fact rejected trenchantly by this court and was said to be no good. Similarly, at paragraph 94, our learned friends call in aid the first High Court judgment at paragraph 194.8 by saying that our approach violates the separation of powers. But again, that was trenchantly rejected by this court at paragraphs 144 to 145. So much of the argument that is advanced relies on propositions from the first High Court judgment, which this court rejected and overturned in its appeal. But more glaringly is that there is a constant refrain in the heads of argument by our learned friends that there is no difficulty here because the member of the executive will not have knowledge of who made the donations. And if I might read to the court what our learned friends say in paragraph 48, they say the following: the risk of corruption only arises when the member of the executive is aware of the persons from whom donations and financial support is made to the member's political campaign. This can appropriately be addressed in the code. Now let me pause there. I'm not sure what that means. I'm not sure whether that is a contention that it is appropriately addressed or could be appropriately addressed. But it seems that it's the former, because they then say the limitation that a disclosure need only be made when a member of the executive personally benefits from funding of their political party position ensures that donors or contributors are aware that their financial support would not be known to the persons they support, and accordingly they cannot ultimately improperly benefit. So the argument goes, if company X donates to DM 2022, the campaign to elect Deputy President Mabuza as the Deputy President of the ANC, just to take one random example, that in that case, there's no problem as long as Deputy President Mabuza doesn't know who donated. And that argument is continued again and again. Paragraph 51, our learned friends say, a blanket requirement of disclosure, even when a member of the executive has prudently run their campaign in a manner that does not allow them access to information about specific donors, creates an unnecessary risk of corruption. And they say it again at paragraph 52 and paragraph 87 and paragraph 88. So that's 48, 51, 52, 87, and 88. So the gist of the argument goes, it's better to make sure that there is a Chinese wall or a real wall between the donors and the president or the deputy president or the MEC. And as long as those people, those members of the executive don't know who is donating, then there is no corruption problem. Well, I'm not sure that the premise is good, but even if the premise is good, it's plainly untenable in this case for three reasons. Firstly, that's not what the code says. The code does not have a knowledge requirement. The code does not say that the moment that you know who donated, you must disclose that. It doesn't say that at all. And so when our learned friends say in paragraph 48 that this can appropriately be addressed in the code, well, it's not, with respect. And we invite our learned friends to indicate where it's addressed. Secondly, it's not what the facts of the CR17 campaign were. The facts of the CR17 campaign, and if I could just give the court a reference to the record, it's page 26 of the record, paragraphs 61 to 63. There, President Ramaphosa says, it was agreed that to the extent possible, I would not be directly involved in the solicitation of donations, and that the general practice was that the details of donors and amounts contributed should not be shared with me. And he adds, I attended several fundraising dinners where I outlined my vision for the ANC in the country. The campaign team generally consulted me on the invitation lists for these dinners, and I was very occasionally asked for guidance on possible donors. So even if the test were notionally a Chinese wall, an impermeable Chinese wall, that's not what President Ramaphosa's case was. And so if that is the test, then with respect, something went wrong in the previous case, because on their version, there was a problem. But thirdly, and most revealingly, this court rejected this kind of approach in paragraph 81 of its judgment, which the court will find at page 1744. Because the argument there by the EFF was exactly along these sorts of lines. What the EFF said, and I'll read to the court. In argument, the EFF submitted that the president could not avoid disclosure by willfully remaining ignorant of donations made to the CR17 campaign. This submission misses the point. The issue is not whether the president deliberately kept himself ignorant of matters he was required to disclose. The question is whether there was proof that he personally benefited from the CR17 campaign donations. So this court, quite understandably, did not say President Ramaphosa was ignorant, therefore he didn't need to disclose, therefore there was no corruption concern. That was not the approach that was adopted, and it wouldn't have been tenable on the facts. But so the whole thrust of our learned friends' contentions, which says, as long as there's no knowledge of who donated, you're okay, well, it falls flat. Because even if that were a principled position that was defensible, then the code is unconstitutional because it allows the withholding of disclosure even if you do know. Even if you do know, and you structure it as CR17 or DM22 or AW22, whatever it is, if you structure it separately, you're not in control of who's getting paid, then you don't have to disclose, even if you know. And on our learned friend's own argument, that produces the concern about corruption. So we submit that the attempt to defend by our learned friends simply cannot succeed. Can I then turn, Justice Madlanga, to deal with the second topic? And the second topic is the one which also ties into the question you have raised with me, and it is about the obligations of the code, I beg your pardon, the obligations of the Act. And it is important in our submission to understand the following about the Act. Give me one moment, I'm just finding the correct page in my heads of argument. Yes. So we begin in the heads with the obligations imposed by the Constitution at paragraph 51. But earlier on, we deal with the requirement to publish a code at paragraph 17 and following. And we make the point that the duty to publish the code emanates from section 96 of the Constitution, which speaks about the need to be a code of ethics and speaks about the need to avoid a risk of conflict between official responsibilities and private interests, but doesn't really speak in any specificity about this, understandably, because the idea is that the code of ethics is to be prescribed by national legislation. That's 96.1. And then we come to what the Act itself says. And section 2.1 says that the code must prescribe, quote, standards and rules aimed at promoting open, democratic, and accountable government. So it doesn't contain any particular specificity yet, but what it does say is that the standard, Justice Madlanga, is that there must be standards and rules aimed at promoting open, democratic, and accountable government. And if that does not, if the code doesn't meet it, then of course there's a difficulty. That's 2.1. Then 2.2 says that the code must include provisions requiring cabinet members, etc., at all times to act in good faith and in the best interests of good governance. And B, include provisions prohibiting cabinet members and MECs from acting in a way that is inconsistent with their office, from exposing themselves to any situation involving the risk of conflict between official responsibilities and their private interests. I'm not reading all of them. Or 5, acting in a way that may compromise the credibility or integrity of their office or the government. Let me just pause there for a moment. Those provisions make clear that, I would submit, if they stood by themselves, they would make clear that there is a duty to enact a code that requires some sort of disclosure around money received from private funders, which will benefit you and where you would feel indebted to them, because of course that's the whole point. But then, so even if that was all that the Act said, there would be enough. But the Act then goes further. The Act then says under 2.2c that the code must require cabinet members and deputy ministers to disclose, quote, 1, all their financial interests when assuming office, and 2, any financial interests acquired after the assumption of their office. Let me just pause there. That's the requirement. Any financial interests, including, and we know the word including in that context is not meant to be exhaustive, but to be illustrative, including any gifts, sponsored foreign travel, hospitality, and other benefits of a material nature received by them or by such persons having a family or other relationship, as may be determined in the Code of Ethics. Now what we say is that what that means is that the Act was deliberately trying to draw a broad net and say, you have to disclose all of your financial interests that you have when you come in, or all that you get after you've come in. And what was expected by Parliament was that the code enacted by the President would give greater specificity to make sure that nothing fell through the cracks. And that's what the President tried to do, President Zuma in 2000. But with respect, he failed. Because what the code does instead is, instead of providing greater clarity and specificity, it just repeats these words. And so we're left with the same difficulty that this court had about trying to understand what does financial interest mean, what does material benefit mean, etc. And so we are left with a series of provisions which don't actually aid it. So Justice Matlanga, when you ask me, does the Act require this? Well, the Act doesn't say you must disclose, the code must require the disclosure of political donations. Just like the Act doesn't say you must disclose the sponsorship of your study, or the Act doesn't say you must disclose when you receive shares. It doesn't say specifically, because the whole point of the Act was to say the code must cover everything. It must cover everything that could create those conflicts of interest, which were referred to in section 2.2.
That point, I know you are still responding,
Yes.
But at that point, that the code must cover everything. And as I understand you, this is something required by the Ethics Act.
Yes.
I've heard your argument about paragraph 141 of our judgment. But you are aware that we sometimes say we were wrong, even if, as we said in Boanya, we may not have the courage to say we were clearly wrong, but we sometimes do say that we were wrong. Just at that level and with that possibility in mind, why is it that we do not test the code against the Act and not so much the Constitution directly, as I understand Amabhungane's argument?
Justice Matlanga, thank you.
I'm not saying Amabhungane are not at all relying on the Act, no. But there is the aspect of also directly relying on the Constitution.
Yes. Justice Matlanga, you've taken the words out of my mouth, which is I was going to say we very expressly rely both on the Act and the Constitution. And the reason that we do so is because it seems to us, with respect, that even if there were no obligations under the, let's say that the Ethics Act said only one thing. The president must enact an ethics code to deal with the behavior and the conduct of members of the executive. Let's say that's all it said. It was a one-liner. I don't understand the principle of subsidiarity to say when you enact that code, you no longer have to comply with the Constitution, unless you are in the very specific area of subsidiarity, which says this was an act designed to cover the field. It was designed to prevent you relying directly on the Constitution, the labor cases, etc. So even in that world, if the act had had that one-liner which says the president shall determine the code, I don't think we'd be precluded from relying on the Constitution. But in this case, we're certainly not there, because of course what we have here is an act which sets the standards, and it's that standard that I read to you. The standard that is set is standards and rules aimed at promoting open, democratic, and accountable government. Now, how do we know what the standards are that are aimed at promoting open, democratic, and accountable government? Well, we look at our Constitution. And so it matters not to my client whether you say this code is inconsistent with this code is inconsistent with the Act as read in the light of the Constitution, or whether you say this code is inconsistent with the Constitution. It doesn't matter. The answer is the same, because of course, when this court interprets the Act, it has to do so in light of 39(2) in a way that promotes the spirit, purport, and object of the Constitution. That's the first point.
Mr.
The second point,
please continue.
Thank you. But the second point, sorry, Justice Turon, the second point is, this is conduct of the president. And conduct of the president has to comply with section 7(2) of the Constitution. And 7(2) is that the president has to respect, protect, promote, and fulfill the Bill of Rights. And as held in Glenister, has to take reasonable measures to combat corruption. So when the president receives a power from Parliament, he must exercise it in a way that he takes reasonable measures to combat corruption. If he didn't, then there is a problem and there's a violation of 7(2). I'm sorry, Justice Turon. Thank you for allowing me to finish the question.
I'm sorry, my sister. I'm not done. I know you saw I was muted. It must have happened instinctively, my sister. Sorry. My second last question, Mr. Badlander.
Yes.
It seems that the Ethics Act is directed at open quote cabinet, close quote, and open quote deputy ministers, close quote. Now, when somebody is campaigning to become a member of, let us say, the executive, not of government, but of a political party, it's easier with the president, if they do get elected as president, and let us say we are in 1999, where everybody would, have, it would be a very good guess to say in 1999, the ANC is going to win. So if you get elected as the president of the ANC, it's close to a foregone conclusion that you will be the president of the country. But as for the other positions within the executive, in fact, as I understand it, what is it not 80-something members of the ANC, for example, who are members of the executive? That's far removed, I would imagine, from eventually becoming a member of cabinet or becoming a deputy minister. Does the Ethics Act require that for that sort of campaigning, you must disclose that in terms of the Ethics Act, or rather in terms of the code as proclaimed in terms of the Ethics Act? And if you say yes, what exactly is the connection, or what exactly is the basis? And the Ethics Act in terms, or in so many words, refers to members of cabinet. And when you got this 2 years before, because I think it's usually roughly 2 years before, with the ANC at least, before the government then gets constituted. So 2 years before, you were campaigning as an individual and you got these benefits. Just tell me the connection for purposes of the Ethics Act and therefore for purposes of the code, why you would then have to divulge this. I'm not saying the Constitution does not require it, but I guess my point is more, does the Ethics Act require it? Does the code require it?
Yes.
Justice Madlanga, I'm sorry to interrupt. Just to place on record that Justice Matopo was not with us, but I think that was only for a minute or two that we were not correct.
I thank you, Justice Throne. I always explain to counsel that we do not stop proceedings if a justice loses connectivity. And but thank you very much for bringing it to my attention.
It might be important today because we only ate.
Because we have the practice of saying a justice will listen to the recording, will also read their clerk's notes, and if they want to raise issues relating to that period when they had lost connectivity, we may issue directions for that to be addressed. I think we continue to operate on that same basis, even if we are 8, my sister. Otherwise, with the problems of load shedding, I lose connectivity, we stop. I come back on, you lose connectivity, we stop. We would never finish. And I think that was the basis why we adopted the stance that we did. And I think even if we are 8, we should continue that way. But thank you for alerting me. Thank you, my sister. I think I was done with the question, Mr. Badlenda.
Yes, thank you. Justice Madlanga, let me deal with the question in these ways, if I may. Let us assume that Mr. Smith runs for the NEC of the ANC. He's a middle-ranking member of the ANC, and he now wants to run for a highish level position on the ANC. And in order to get that high level position, he receives a donation of R1 million from Stephen Badlenda. Or more accurately, Mr. Smith has a separate campaign called Mr. Smith for the NEC, and I donate R1 million to Mr. Smith. Mr. Smith then becomes the NEC. He gets onto the NEC. He might be as high as he likes or not. But he then becomes the Deputy Minister of Social Development, or the Deputy Minister of Water Affairs, or the Minister of Water Affairs, because we know how these things interact. I am now putting in a tender, which Mr. Smith is either involved in designing or involved in awarding, or he's designing a policy which might benefit me. I would ask, is there a conflict of interest? Is there a risk of government being seen as beholden to Mr. Smith if he received R1 million to benefit him in a campaign, which resulted in him not being the president, but resulted in him being in the NEC, and which indirectly led to him? I would submit that there is plainly a conflict of interest. The question that you ask, and there would plainly, under the Ethics Act, be a duty of disclosure. You ask a slightly different question. You say, does the conflict of interest survive 2 years after I paid the R1 million to Mr. Smith? In other words, where I paid him the R1 million at an ANC conference or a DA conference 2 years before he's elected, should he still have to disclose that? And my answer is that I would submit that he does, because he still knows who he received the money from. But I accept that that might be a legitimate line that could be drawn by the code. The code could legitimately, potentially, and I'm saying this, I want to be careful. I want to say potentially, the code could say, any donations received within the year before you were elected must be disclosed, but donations received prior to that need not be disclosed. And we could then have a legitimate debate about whether there is a legitimate governmental purpose behind that, whether that gives effect to the act, etc. But the present code, Justice Madlanga, does none of that. The present code says, and of course we know sometimes the ANC conference is very close to when people are elected to cabinet. The present code says, even if Mr. Smith received R1 million a week before he took office, he doesn't have to disclose it. Even if he received R1 million while he was in office and he was running for the next ANC campaign, he doesn't have to disclose it. And so I accept that there might be areas of gray and gradations where the president could legitimately saying, I'm going to define in these political donations and out those. And the order that we seek would allow that. But then the president must do that, and he must come and defend the lines that he draws. What he cannot do is have a code which at the moment allows people to drive a truck through it, because all you do is set up the separate entity, say you don't have control, and no donations have to be disclosed. And that would be my answer, Justice Madlanga.
And is that covered by the broad concepts set out in Section 2.1, or is it covered by something more specific under somewhere under Section 2.2?
Well, I would say it falls under all three. I would say, firstly, it is a standard and a rule aimed at promoting open and democratic and accountable government, particularly when you read it in light of 7.2 and Glenister, which I'm going to come to in a moment. Secondly, I would say that it falls under 2.2b3, which is exposing themselves to any situation involving the risk of a conflict between their official responsibilities and their private interests. And it would fall under 2.2b5, acting in a way that may compromise the credibility or integrity of their office or the government. But lastly, it falls under 2.2c, because it is a financial interest of the sort envisaged by 2.2c. And I accept that 2.2c speaks about financial interests when assuming office. And that's why I say the president could legitimately say, well, if it happened 10 years ago, you don't have to disclose it. If it happened a year ago, you do. That might be a line the president could draw. But I submit it falls under all three, even read cold. But when you read it in the light of Glenister and 7.2, it certainly applies there.
Thank you, Mr. Badlender.
Justice Madlanga, before I leave you, could I make one last point, which I omitted to make on your subsidiarity question? It seems to me the one time we would have had to challenge the Ethics Act is if the Ethics Act had expressly excluded political donations. Let's say that the Ethics Act had said, the code must require the disclosure of all financial interests, excluding political donations. Well, then I accept, of course, that the code didn't have to. And we would have then had to challenge the Act, because you can't go behind the Act indirectly. But in the present case, where the Act casts the net very wide, particularly in light of Section 7.2, the subsidiarity problem doesn't arise in my submission. Sorry, it occurred to me, and I wanted to just close that loop before we lose the thread.
Thank you, Mr. Badlender.
Mr. Badlender.
Yes.
In Public Protector, this court suggested that donations to interpolitical party campaigns are not per se disclosable under the Act. Would you agree then, by implication, that such donations do not constitute a benefit of a material nature as defined in paragraph 6.4 of the code?
Justice Turon, forgive me, as I have it, this court held that they are not per se disclosable under the code, not under the Act. Did I misread that?
Yes. No, that's what I said, Mr. Badlender.
Oh, I'm sorry. Perhaps I
or that's what I meant to say.
I apologize if it was my error. I accept, as I must, this court's judgment that on the code as presently formulated and as interpreted by this court, donations to political parties are not per se disclosable. I accept that. And that is, in my respectful submission, exactly what produces the constitutional problem and the problem of invalidity of the code.
Now, in light of our decision in Public Protector, and if you accept that, on what basis can we find that financial interest, as it appears in the Act, includes such donations?
Because with respect, what this court did is this court adopted a reading of the code which emphasized the phrase personal benefit. This court held that the way that, as I understand it, that the way that the code is drafted is it focuses on personal benefit. And so when the cash is received by me as the member of the executive, then it is a personal benefit, and then it has to be disclosed. But this court was not confronted with and did not consider whether the phrase financial interest in section 22C of the Ethics Act was sufficiently broad to cover campaign donations. And it particularly didn't consider whether that phrase read in the light of 39.2 and 7.2 was sufficiently broad. And the reason that this court didn't do so is because of the slightly odd bifurcated approach that the court had to confront, where the court was only interpreting the code and was not dealing with the challenge.
If we were interpreting the code and the act simultaneously, if that is what had happened or what we were doing now, could we hold that financial interest in the act includes intra-party political campaign donations as set out in 6.4 of the code? And it will fall under benefits of a material nature.
Justice Taron, it seems to me with great respect that that's the wrong question. And the reason I say it's the wrong question is because you are asking me.
Is it just not perhaps a difficult question for the applicant?
Well, of course it's a difficult question. Otherwise, you wouldn't be asking it to me. But I'm answering. But it is the wrong question, if I may submit why. You are asking me whether a campaign donation falls under a material benefit under 6.4. And my answer to you is I have to accept that it doesn't, because this court has held that it doesn't. But that's not the right question, because at the moment we're asking, does that code, as presently written and as interpreted by this court, comply with the standard laid down in the Ethics Act? And the standard in the Ethics Act is not personal benefit. The standard in the Ethics Act is financial interest, any kind of financial interest. And so what has happened is that the president has, no doubt inadvertently or for the best of reasons, narrowed the scope of the kinds of financial interests that have to be disclosed and has not defined it sufficiently broadly. And we say that is the difficulty for the code.
Isn't there two options for this court, Mr. Budlander? One, this is based now on the answers that you've given, that we would have to find that we were wrong in public protector. The other option is, if we find that the code does exactly what the Act says it must do, in the absence of a challenge to the Act, we would not be able to hold that the code is unconstitutional.
Justice Ron, I don't accept with respect that those are the only two options. Indeed, this court could say it was wrong in public protector, and in fact, 6.4 does cover a donation to a political campaign. But if this court rejects that and says it was right in public protector, that doesn't preclude it from striking down the code because of this reason. I have already explained that what one needs to do is view the Act in light of the Constitution, which is what I'm going to come to. And what nobody has given an answer to is how can it ever be consistent with a duty to take reasonable measures against corruption when you're enacting a code to say we are going to exclude political donations as long as they're not paid to you directly. And if that is so, then the code is the problem, not this court's judgment and not the Act. It's the code that is the problem, because the code is the one that doesn't give sufficient weight to the need to avoid the risk of conflict, to the need to, and again, if I could read that standard, to the need to have standards and rules aimed at promoting open and democratic and accountable government. There's nothing, if I can take a step back, let's pretend that the code doesn't exist, just for a moment. We're in 1998. Parliament enacts this Act. And someone says, well, would this include a donation to a political part, to an internal political campaign? Everyone would say, of course it does, because that creates the risk of conflict. This is meant to be standards and rules aimed at promoting open, democratic, and accountable government. And it produces exactly the kind of risks that 22A and B speak of. So until the code came in, everyone would have said this Act, of course, is broad enough to allow for that. The president, however, enacts a code which, as interpreted by this court, goes narrower. And that is what creates the problem. So the proximate problem is the code, not the act, in my submission.
If we put aside our decision in Public Protector for a minute,
Yes.
and if we were interpreting the code and the act together at the
Yes.
same time, could we hold that financial interest in the act includes inter-party political campaign donations, but that benefits of a material nature, as in 6.4 of the code, does not?
I just want to make sure I understand the question. The question is, assuming that there was no public protector judgment, you could, although I would argue that you would be wrong to. And perhaps I could just explain why in that world I could argue that you would be wrong to. The Act says financial benefits I beg your pardon. The Act says financial interests of any kind. It says any financial interest. When you go and look at the code, what the code says is every member, this is 5.1, every member must disclose to the Secretary particulars of all the financial interests as set out in paragraph 6. So we've got an act which says any financial interest, and then we've got a code which says in 5.1, you must disclose the financial interests, only those set out in paragraph 6. And then what is listed is a series of financial interests. The first one is shares and other financial interests in companies. The second one is sponsorships. The third one is the gifts. The fourth one is benefits. And I would argue in a non-CR17 world, if we were debating, and that's what you're asking me to postulate, I would argue that the fact that benefits is so vague must be given the broadest meaning possible. And I would argue that benefits doesn't say personal benefits, it just says benefits. And I would argue that it must be read broadly to accord with what the code says, what the Act says is any financial benefit. So in that world where you're asking me to wish away the public protector judgment, that is what I would argue. And I would argue that the code could be interpreted in that light. But the problem is that this court has already held that that's not what the code means, understandably. But once that is so, then there is a constitutional and a statutory problem because there is a conflict between the code and the Act.
If we don't see a conflict between the code and the Act, and coming back to this matter that we're dealing with now, without, in the absence of a challenge to the Act, on what basis can we hold that the code is unconstitutional?
You can do so. Well, let me say, if you hold that there is no conflict between the code and the Act properly interpreted, and I want to come back to that proper interpretation in a moment, but then of course you can't declare the code in violation of the Act. I appreciate that. But my submission is you would still be able to declare the code in violation of the Constitution, because the principle of subsidiarity, as this court has laid down and made clear, is not a fixed and rigid principle. It depends on the circumstances, and it depends on whether there is something, an enactment which is intended to cover the field. And I don't understand this Act to be intended to cover the field in that way. I don't have the subsidiarity case at the top of my fingertips, but I'll give it to you in reply. But this court has made, it was the case about the class action in which this court made clear that subsidiarity is not a fixed and rigid rule and depends on the circumstances. And so, Justice Theron, in my submission, this court could say, it's true that the president has followed his obligations under the Act, but the president has not upheld his obligations under 7.2 of the Constitution, a la Glenister, and therefore the code should be struck down.
My last question, Mr. Badlander. If one looks at the general phrases used in the code, for example, financial interests in paragraph 6, paragraph 5, disclosure of financial interest, conflict of interest in paragraph 3, and doesn't that accord with the phrases as they are used in the Act?
Yes, except for this. and that's an important point. If paragraph 6 had said, members must disclose the following interests, 6.1, any financial interests, then there could be no debate that the code was consistent with the Act, because the very same phrase would be used. But have a look, if you would, Justice Taron, at what 6.1 says. It says shares and financial interests in companies and other corporate entities. So what the drafters of this code have done, I'm sure inadvertently, is that they have not said disclose any financial interests. You only have to disclose your financial interests if they are like shares, if they are shares or financial interests in any companies or other corporate entities. And then come other species, sponsorships, gifts, benefits, etc. Whereas the Act speaks about any financial interests implicitly of any kind. And so that is what has actually caused the problem here. Because if 6.1 had said shares and other financial interests in companies, and 6.2 had said any financial interests, I wouldn't be having this debate with you, because I would then accept that the code and the Act map perfectly onto each other. There is no narrowing by the code, and therefore the code can't be regarded as breaching the Act. But it's because 5.1 says you must disclose all of your financial interests as set out in 6. And then you go to 6, and 6 doesn't say all financial interests. It's only those listed in 6.1 through to 6.7. And there is one missing. There is financial interests other than those held in companies and corporate entities. And that is what causes the problem. Thank you, Justice Taron.
Thank you, Mr. Budlander. Thank you, Justice Matlanga.
Mr. Budlander, I wonder if I could take up a question which flows from what my sister, Justice Taron, has been asking you.
Yes, of course.
Coming back to the language of financial interest, if the campaign donations are made to an entity, such as a campaign, of which the minister or the president is separate, in what sense can it be said that it is their financial interest? In other words, to the extent that the campaign is separately constituted from the person who is the aspirant office holder, in what sense is the money paid into the campaign a financial interest of the person ultimately elected to office?
Yes, and Justice Untitled, I apologize for asking, but my understanding is you're asking me in terms of understanding the Act rather than the
yes, specifically C1 or C2, but yes. What is the broad concept of financial interest that you contend for that would answer that question in your favor?
Yes, I would submit that it is it's the equivalent of pecuniary interest. It is an interest in the sense that the president or whoever it is has no control over that company. And yet, because that company was set up with the purpose of funding his campaign for office, he has an interest, a pecuniary interest, if I can call it that, in how much money that campaign has. Because its ability to fund his campaign events and his adverts and everything else will depend on how much money that campaign has, which in turn depends on what donations it gets.
Well, I'm wondering if the analogy isn't a little bit more like a trust of which a person is a beneficiary, so that the financial interest is that the outcome of the use of the campaign is to benefit the person, and hence there is a financial interest that arises.
Justice Unterhalter, you're not going to believe me, but it was on the tip of my tongue to say trusts, but I have such an anxiety about my limited understanding of trusts that I went in the other direction. That to me is exactly the appropriate analogy. A person who is a beneficiary of a trust has no control over the trust, and indeed we know the trustees do so, and yet there's unquestionably a financial interest in the trust, because of the monies that are likely to flow. And with respect, it's a very good analogy that you've put to me. And I wish I had encouraged my convictions.
Can I then just ask you some other statutory language, which is just around the conflict of interest, which you also rely upon?
Yes.
That contrasts official responsibilities and private interests.
Yes.
Is a campaign pursued for an office within a political party a private interest? And if so, why?
Yes, my understanding is it is a private interest, and that's what the gist of this court's judgment in the public protector matter said. Because the reason that this court held that the public protector had no jurisdiction to investigate the CR17 campaign is that it was essentially a private matter in that sense. Now, of course, it's not a typical private matter, but that it wasn't a public matter or the exercise of any public power. That's the first point. And the second point is, of course, the ANC might be very important politically and publicly, but the question of whether Stephen Budlander or Justice Unterhalter gets elected to a particular position there is a private matter and a matter of private interest. So I do submit that that's a private interest question.
And then lastly, if I may put to you the language in section 2.1, which references that the code must be aimed at promoting certain things.
Yes.
I'm wondering with what specificity that can be exacted in particular features of a code of ethics. In other words, if a code is perhaps partial and even possibly inadequate in certain respects, it may still be aimed at the virtues that the section points to. In other words, it's the difference between something that is aimed at an objective and where, without referencing some feature of ethics, it would be so deficient that it wouldn't meet the standard, it wouldn't meet the requirements of 2.1. I'm wondering how we interpret the language of aimed at.
Yes, it is. It's, I suppose, the difference between the purpose of the code and the standard that the code must meet is what you're really putting to me. And it seems to me that I would answer it in two ways with respect. The first is that I accept that I must accept that a degree of deference is given to how the president seeks to achieve those aims. And so that if there is more than one way of doing so, then the president will be given deference as to how he does it. And the court will not say, well, it could have done something different. And that's consistent with this court's reasonableness doctrine. And it's consistent, in fact, with what this court said in Glenister about 7.2. But here is the second point, and the critical one. Here you are faced with a president who has not explained at all why it is that the approach taken by the code is indeed aimed at promoting open, democratic, and accountable government. Now, it might be that some other president could have said, look, I've decided to exclude political donations because of A, B, and C, or I've decided what is there is sufficient. In those circumstances, we would be having a debate about deference and reasonableness. But here we have no such debate because the president has twice declined to go on affidavit and explain why that's position, and now does not even come to this court to seek to defend it. And so I don't ask you to read aimed at as meaning standards which achieve open, democratic, and accountable government, but I do say that it must be given some meaning. And in the absence, we submit a glaring absence in this case, and the glaring absence of regulation of political donations, and then a glaring absence of any explanation, we submit that is enough to say that there is a breach of 2.1. Let me say also, Justice Unterhalter, that the aim as set out in 2.1 must color the meaning of financial interests as set out in 2.2c. So when you look at how broadly to derive 2.2c, what tells you that you should adopt a beneficiary-driven approach, which is really what you've put to me under 2.2c, rather than a strict financial approach, that aim must indeed inform that interpretation.
Yes, thank you. Thank you, Justice Madlanga.
Mr. Butler, may I take you to another topic altogether, please? And that is the Party Political Funding Act.
Yes.
The amici make much of the availability of this act instead of the Ethics Act, as you know.
Yes.
Well, it does seem to me the Party Political Funding Act, if you look at the long title and the preamble, has another objective altogether. But what intrigued me about this act is section 10. If you do have it there, if you could go there, please.
I do have it. Thank you, Justice Majid.
It reads as follows. The caption is prohibition on donation to member of political party, and reads 10.1 is the one I'm interested in. No person or entity may deliver a donation to a member of a political party other than for party political purposes. How do you read that section? Could it possibly accommodate what is required in section 96 of the Constitution, some other interpretation that there's a absolute prohibition to donations, and hence if there is a donation, it may fall foul of requirements of disclosure. How do you read this section 10.1?
Thank you, Justice Majid. Justice Majid, I read it with great difficulty because it is entirely unclear to me. But it seems to me that it's capable of two interpretations. The one interpretation says, and I think you need with respect to read 10.1 with 10.2. 10.2 says, a member of a political party may only receive a donation contemplated in one on behalf of the party. So it seems that it has at least two interpretations. The one is that what it does is that it prohibits any donation to a campaign to elect Alan Winder for for president of the DA, or it's an absolute prohibition. Now, that would be quite an extraordinary change in our law, because what it would mean is that in a stroke, Parliament has done away with any form of funding to any political party in the country. And I must say, I once had occasion to try and look at this and with Hansard, and there was no suggestion that that was the case. But the alternative interpretation seems to be that it is that you can have a donation to Alan Winde, who's running for chair of the DA, but that you have to donate it to the party, and the party then has to donate it to him. The party, in other words, becomes the sifting mechanism. But again, that's difficult to understand. But could I take the coward's way out?
Sorry to interrupt you. I must say that is the difficulty I had in interpreting this section and trying to see if it could fit in. Yes. As part of the answer to the question before us, but it's with great difficulty that one understands what is meant by 10.1, and you're right, you should read 10.1 and 10.2 together.
Yes.
Sorry, I interrupted you.
No, not at all. Could I give you a route out of that conundrum, because it really is an impossible conundrum. And the route out is that for present purposes, it doesn't solve the problem, even if it means that you have to donate to the party. And this is the reason. 10.1 and 10.2 speak about donations to a party, to a member of a political party. Now, on this court's judgment in Public Protector, the donations that were made to the CR17 campaign could never be said to be donations to President Ramaphosa. They were not to President Ramaphosa in that sense of the word. They were donations to the CR17 campaign, which was a separate legal entity over which President Ramaphosa had no control. So whatever you read 10.1 as meaning, it cannot possibly have any effect on the problem in this case, because it does not avoid the creation of a separate legal entity, CR17, DM22, and the solicitation of donations in that way. And so whatever it means, it doesn't solve the problem. And therefore, it doesn't render the ethics code constitutional, because it doesn't create a disclosure mechanism.
And then just on another piece of legislation, PAIA. Yes. Again, the amici also resort to PAIA. And while I do have difficulty with how that all fits in, I just want to, I've read your heads, but I just want to hear your views on whether PAIA could possibly assist here, because it seems to me with PAIA, there needs to be a complaint or a request. Yeah, a request, not a complaint, a request. Now, I'm not sure how that would feature in where there is a difficulty with a donation that isn't publicly disclosed. How do you
Yes.
see the PAIA answer given by the amici in this case?
Yes, with respect, PAIA is a complete red herring for purposes of this case, for the following reason. We are dealing here with a code and an act, which for very good reasons say there must be automatic disclosure of financial interests. Every member of the executive, and we're talking about members of the executive, people with enormous powers, every member of the executive must disclose on an annual basis all of their financial interests automatically. PAIA doesn't achieve that. It's never purported to achieve that. PAIA is designed to enable Amabhungane or News 24 or the LRC to bring a request for specific information about a specific person. And let me tell you, from my experience, it is a long and cumbersome process. Now, to try and achieve what the Act envisages, what you would have to have is 96 or no, well over hundreds of PAIA requests brought every year by that NGO to every member of the executive at national level and every member of the executive at provincial level. It would be an inordinate waste of time, and by the time the information was obtained, it would be outdated. 96 and the code and the Act serve a different purpose, and the purpose is automatic disclosure by people in positions of power to ensure exactly what this court said in My Vote Counts Too, which is to act as a bulwark against corruption and to provide information. Relying on PAIA to do that would simply not achieve it at all.
Yes, thank you, Mr. Butler. Thank you, Justice Matlanga.
And let me just say, to round off the point, this court made absolutely clear in its judgment, and I appreciate that this court sometimes is wrong, Justice Matlanga, but it was certainly not wrong here. But what it said at 142 is it says the issue is not whether there are other pathways leading to such information, nor is it about access to information. And it specifically rejected the reference to PAIA in paragraph 142 of its judgment.
Thank you, Mr. Badlender. I did not want to interrupt my brother, Justice Majid, in his questioning. Your time is up. How much more time do you want?
If I could just have 10 minutes at the outside, and I will try and be more brief than that, Justice Madlanga.
Take the 10 minutes, Mr. Badlender.
Thank you very much.
Perhaps, I'm sorry, Justice Madlanga. Before the clock starts on your 10 minutes, I'd like to ask a follow-up question from what you were discussing with Justice Majid and Section 10.1 of the Party Political Funding Act. Is Section 10.3 not relevant, Mr. Badlender, which is a circumvention provision which says no person may circumvent the provisions of Section 10.1 and 10.2?
If I understand the question, in other words, that if you were to set up a separate entity, yes, you would be circumventing that. Well, yes, with respect, Justice Tehran, you are then on that reading an extraordinary thing into Section 10, because what you are saying is that Parliament has, at a stroke, forbidden any form of private funding of individuals running for public office. I'm sorry, running for internal party campaigns, and has forbidden them doing so even via a separate legal entity over which they have no control and which might have been set up without their control. So what you see, for example, and I am very loath to mention the US, but what you see in the US in these campaign finance things is that the politicians stay clear deliberately and genuinely to avoid being hit by campaign finance laws. And you have these entities which raise funds and provide funding for the campaign of Stephen Badlender or Mr. Smith, where the politician was not involved in setting it up, did not control it, and had no degree of control. Now, it's difficult to say in those circumstances that the politician was involved in any form of circumvention. And similarly, it's difficult to see how you could say that the people involved in setting that fund up are circumventing the provisions of this chapter, because they would say that they are simply collecting donations and doing as they choose with it. So I accept that that would be a possible reading, but it would be an extraordinarily far-reaching reading to adopt in a case where you've heard virtually no argument on Section 10, and where in due course that issue is undoubtedly going to have to come back to this court. And my submission is it would be very surprising if that were the effect of Section 10. Let me make one other submission. There is a risk in that reading. if you read section 10 as saying no one may ever make a donation to an internal party campaign, directly or indirectly, what you run the risk of doing is simply driving the funding underground. Because unless you assume that every person is going to comply with this law, you are then going to have a position where those candidates who comply with the law have no money to run their internal party campaigns. And those who don't receive money under the table and do not even have a duty of disclosure. Now, I accept that the court will not lightly brook the idea that the law will be violated. But with respect, one needs to be careful in trying to interpret this law in a way that would really be totally unrealistic in the present status quo.
Thank you, Mr. Butler.
May I invite other colleagues before the 10-minute countdown begins? Any other colleagues who have questions?
Thank you, Justice Madlanga. I just have one brief question. Mr. Butler, the High Court's order in paragraph 1 at page 1818 finds that the code is unconstitutional because it does not require the disclosure by members who are the subject of the code of donations made to campaigns. So what the judgment would then say is that for the code to meet the test of constitutionality, all donations made to the campaigns for the elections would have to be disclosed. Is that the order you seek, the confirmation you seek from this court as well? And if so, would that have the effect of creating a duty on members, a positive duty to inquire with regard to every conceivable donation, even if a donation was made to a slate? So for example, if a donation was made to a slate and saying we give this money to support 6 candidates, to then be able to dissect and disaggregate and quantify that donation, and that would be the subject of disclosure in order to save the code from unconstitutionality.
Thank you, Justice Collopin. I read the order slightly differently. It says it's declared that it's unconstitutional insofar as it does not require the disclosure. So I understand it to say that not that it doesn't require any, but it's insofar. But I understand your question to be slightly different, and I do appreciate it. You're saying, would the effect of that order be that every campaign donation has to be disclosed, failing which it's unconstitutional? And my submission to my answer to your question is that's not my proposition. I must say that from my client's point of view and from a principal point of view, we think there is much to commend that position, that every donation should be disclosed and that a 6 slate, it should be disclosed by every member of the 6 slate, etc. But I don't understand that this order or this court's or the High Court's judgment would preclude the president saying, I have drawn lines in this way. I have widened the disclosure of campaign funding, and I do so in the following ways, but I've excluded something from 10 years ago, or I've excluded a slate that has 150 people in it and where nobody knows or something. This is purely theoretical, but I do not understand that this order would preclude that, because the judgment of this court in Public Protector 1 makes clear that it would still be for the president to determine the lines. And that is precisely why there's a suspension in order to allow the president to do so.
Thank you, Justice Madlanga. Thank you, Mr. Butler.
Thank you. And indeed, it would be an invidious position for this court to have to start drawing those lines in this judgment, because it would really undermine the very purpose of suspension, which is to allow the president to make that call.
The 10 minutes starts now, Mr. Butler.
Thank you very much, Justice Madlanga. The only points that I haven't covered that I just want to say one word about. The first is that I have repeatedly made reference to Glenister. I'm sure I don't need to tell this court what Glenister says, save to just make one point. What Glenister does is it creates a duty of reasonableness when it comes, or reasonable measures test, when it comes to the exercising of public power, legislation or otherwise. And so here what we have is that the president had a power to enact a code with a particular purpose. And in doing so, he had to, in our submission, act reasonably and adopt reasonable measures. And in light of what this court said in My Vote Counts 2, we submit that he has not adopted a reasonable measures approach, and we would simply commend to this court what was said in Glenister at paragraphs 189 to 202, and particularly when one has regard also to the United Nations Convention Against Corruption, which we've referred to in our heads. And that, of course, must be read when one is interpreting the Act in the questions that you put to me, Justice Madlanga, and that Justice Saron put to me. One must do two things. One must interpret the Act in light of 39.2 and the duty to promote all of the values which are set out in this court's judgment in my vote counts 2. But one must also interpret the President's duty in light of section 7.2 and what this court said about the duty to have corruption busting mechanisms in Glenister. And the idea that disclosure of donations is a corruption busting mechanism is not my idea. It's what this court said in my vote counts 2, and it said so unequivocally that automatic disclosure of donations or of money in politics is one way of combating corruption. So that's the first point I would wish to just summarize. And then the other 2 points which I would wish to make are those that appear in paragraphs 62 to 63 of our heads, which is, we say that what we've said is enough in order to render the code unconstitutional and unlawful. But there are 2 additional problems. The first is the problem of vagueness, because the difficulty that we have had in just this engagement in trying to understand where the lines of disclosure are and are not demonstrates how problematic the code is. Because the whole point of the code was to try and be specific about what had to be disclosed to avoid these kind of ambiguities. You don't want a debate about what members of parliament had to disclose and what they didn't, and public protector investigations and accusations of political mudslinging. The whole point was that the code was meant to be clear. And we commend to you what the High Court said in paragraph 44, which is what members, we know that the code requires disclosure of internal party political funding by campaigns if this constitutes a personal benefit. However, what members and the public do not know with certainty is what constitutes a personal benefit beyond the obvious case where money is given directly to or placed at the disposal of the member herself. In at least this respect, the code is not an effective means of achieving accountability, transparency, and openness. And we're alive to the doctrine of vagueness, and we are alive to the fact that it's not perfect lucidity and that some flexibility is required. But where you are enacting a code which is designed to promote automatic disclosure by members of the executive from around the country, it's critical that there is sufficient clarity, and it's not obtained in this regard. And lastly, and I beg apology for those who sat in the public protector case, but I would refer to the example we gave in the last public protector case about the arbitrariness of what the code does on the present interpretation. And I go back to the example, and again, beg forgiveness, that if I give the Minister of Health 2 bottles of wine for his birthday worth more than 500 Rand, he's got to tell the world about that a year down the line at his next disclosure. And let's be honest, you can't even buy very much these days for 500 Rand, but that he's got to tell. And if I am a company and I give him rent-free accommodation for a month worth 5,000 Rand, he's got to tell the world that. And if I'm a company and I pay Wits University 50,000 Rand so that Minister of Health can complete his master's in good faith, no quid pro quo, he's got to disclose that when he completes his master's. But if the company provides a 5 million Rand donation to CR17 or to AW 2022, and he doesn't have control over it, and even if he's the only candidate, and even if he knows about it, even if he knows the name of the company, even if he invited the company to the dinner, even if he knows that 5 million Rand, he doesn't have to tell anyone. That, with respect, is entirely arbitrary. And it is a product of the unfortunate drafting of the code. I'm sure it wasn't intended, but that disjuncture can never be constitutionally sustainable. And we make the point, in all 4 situations, there's money that's been used to the private advantage of the minister. In all 4 situations, there's a risk of a conflict and a risk of corruption. But in 3 of them, disclosure is required, and in some, there aren't. And the very last point we make on that score is this. The debate about whether the minister ultimately gets elected, or the person ultimately gets elected as president, or whether he ultimately gets top 6 of the ANC or only ends up at number 20. That's utterly irrelevant with respect. Because the fact is that the minister knows some companies spent 5 million rand trying to get him onto the top 6 of the ANC. He only ended up at number 20. He's still the Minister of Health or the Minister of Water or the Minister of Home Affairs. He knows who put that 10 million rand in. Whether the 10 million rand succeeded or not is not the question. The point is that he knows who put the money in, and that creates the conflict of interest. And there is no way of resolving that conflict of interest absent disclosure. And yet, on the code as it stands, there is no requirement of disclosure. And we submit that could never be consistent with our constitution. Generally, it could certainly never be consistent with our constitution when there is a constitutional and statutory duty to enact a code of this sort. And that is the last point I would simply finish with, which is that the code is not only a code required by legislation, it's also a code which is required by Section 96 of the Constitution. And that's why we're in a very unusual situation and not the ordinary subsidiarity principles that might apply in other contexts. Thank you, Justice Madlanga, for the extra 10 minutes and the indulgence. Those are our submissions.
Thank you, Mr. Butler. We will
excuse me. Sorry, excuse me. Before we adjourn, Mr. Butler, I just want clarification from you regarding paragraph 81 of the Public Protector's case, and as well as section 5 of the code, 6.1 and 6.4 of the code, and together with your submissions that the disclosure must relate to all. And I'm looking at the example that you have given to us where a campaign has been run as it was in the CR17, of which the president was unaware. And this court has said where he is unaware and the EFF submitted that he could not hide behind willful ignorance. He should have disclosed. I just want that clarification on that point, if you could, please.
Yes, of course. My understanding is that the code, Justice Matopo, does not contain a knowledge requirement. The code doesn't say you need to disclose if you know who the benefactor is, but you don't need to disclose if you don't know who the benefactor is. That is not what the code says. And my reading of paragraph 81 is that that is exactly what this court said. This court was essentially saying the debate about knowledge misses the point. The real point is, was there a material benefit, a personal benefit under 6.4? And I accept that under the current code. My submission is that the problem with that is that it produces a situation where even if you know who donated and it goes to a separate company, then there's no personal benefit, and yet you don't have to disclose. So you're left with the worst of all worlds, because the money goes into CR17 or DM22. It goes in via a company whose President Ramaphosa or Deputy President Mabuza knows. They know who it is, and yet they don't have to disclose. And so that produces the worst of all worlds. So my submission is, that is the difficulty with clauses 6.1 and 6.4 of the code, because they don't require donation of those political party campaigns, even if the candidate knows who the money came from. And that creates a massive difficulty.
6.1 limits us, or limits the code to financial interests in companies. And when I read 5.1, it says particulars of all financial interests as set out below.
Yes.
That presents me with some bit of a problem. I'm not too sure that I'm creating the problem where none exists or not.
No, with respect, you've put your finger on the problem that leads to the invalidity of the code. if I could take a step back, Section 2.2c of the Act simply says you must disclose all your financial interests. That's what, and it says the code must require you to disclose all of your financial interests. No problem. We then come to the code itself, and what the code inadvertently does is or presumably inadvertently, is it limits the kind of financial interests you have to disclose for exactly the reason you give. 5.1 says you only have to disclose the particulars of financial interests set out in paragraph 6. So if it's not in 6, you don't have to disclose it. You then go and read 6.1, and you only have financial interests in companies. And that doesn't cover these sorts of donations. You then go and read 6.4, and it says benefits of a material nature. But this court has held that that wouldn't apply to a donation to a political party campaign. So the political donation falls between the stools. It doesn't fall in 6.1. It doesn't fall in 6.4. It doesn't fall anywhere else. And so it doesn't have to be disclosed, even if you know about it. And that's what creates the difficulty, because it could never have been envisaged that that is not the sort of financial benefit that has to be disclosed.
So what do we do with paragraph 81 of this court's judgment?
You say that paragraph 81 is perfectly correct, because what paragraph 81 was doing was interpreting the code in its unfortunately narrowed form. And you are saying, in that case, all that was at issue was the interpretation of the code. The public protector didn't challenge the code. The EFF didn't challenge the code. And my client only challenged the code going forwards. So the challenge was irrelevant to determining the public protector's decision. This
So
court
we would then be required to widen the interpretation of the code as well as the act in our judgment.
No, with
not.
respect. You would not be changing your interpretation of the code. You would be saying, we stick to our interpretation of the code, but on that interpretation, the code is too narrow compared to the act, and we strike the code down and ask the president to fix it. And the president would then widen it to bring it in line with the act. And that's the reason, Justice Matopo, that I was so careful in answer to Justice Theron's question. This court did not hold, it did not consider whether a political donation fell within the duty of disclosure under the act. It only held that the duty of disclosure did not fall within the duty under the code. And so what you've got is a broad act, any financial interest, which includes a political donation, and a narrower code, only some kinds of financial interest, material, personal benefits, which excludes it. And so what you would be saying is, we know the act is broader, we know the code is narrower as we've interpreted it. That now creates a constitutional problem, and we're going to strike down the code insofar as that inconsistency exists, and the president must fix it. That is perfectly consistent with what was said in paragraph 81 of this court's judgment.
So would you then say our judgment must align itself with section 21C?
2C as I have it.
2C as I have it.
Yes, yes.
Okay.
You would be saying that the choice by Parliament in 2.2c to not limit the kinds of financial interests that have to be disclosed was plain from the text, plain from the context, plain from the object, which is in 2.1, and also plain from the constitutional imperative, but that the code goes narrower and therefore the code should be struck down because it goes too narrow.
In other words, if I understand you, we would be giving proper clarification,
yes,
in 2C to 5 and to the code in 5.1 and 6. In 5 and 6.1.
Yes, exactly.
Okay.
You would be saying that 5 and 6.1 need to be brought into line with the broad definition of financial interest in the Act.
Okay, thank you.
Thank you, Justice Matopo.
Let us adjourn until 11:42. Correct, Jen?
Adjourn until 11:42. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:42. Should you exit, you may use the same link to rejoin the hearing.
Ms. Sobikwa.
Justices of the Constitutional Court, all counsel are online.
Thank you. Yes, Mr. Wilson.
Yes, Justice Madlanga, members of the court, we'll advance our submissions under 5 heads with the court's leave. The first is to define what we say is the central question in this case, which ought to focus narrowly on the president's conduct when the Executive Ethics Code was promulgated. The second will set out our core submission that the Executive Members Ethics Act embodies a decision to leave open a particular kind of policy choice about how to deal with conflicts of interest among members of the executive. And we'll submit that, properly construed, Amabhungane's challenge is to the decision to leave open that policy choice and not to the content of the code itself. Then we'll deal with the obligations imposed by the Ethics Act and the Constitution, and we'll show that on a proper interpretation of both, the kind of obligation to disclose that Amabhungane offers for is not necessarily implied or expressly set out in either of those instruments. Fourthly, we'll deal with my learned friend's reliance on my vote counts, and we'll set out why my vote counts deals with a fundamentally different set of circumstances to those that confront the court in this case. And finally, we'll address 1 or 2 submissions on the meaning of the phrase financial interests in terms of section 2(2)(c) of the Ethics Act and its application to the issues in this case. So if we can start with what we say the central question in this case is. And it is, of course, whether in enacting the ethics code, the president had a constitutional obligation to import a provision requiring a minister, a deputy minister, or an MEC to disclose donations to their campaigns for party office. Now, we know from the public protector case that the code already requires disclosure when those donations amount to a direct financial benefit to the minister, or where the entity that receives them does so as the minister's agent. But Amabhungane impugns the code in this case, and accordingly the president's conduct when he enacted it, on the basis that the president should have gone 1 step further. Amabhungane says that the code should require a minister to disclose all donations to any campaign that sought that minister's election to an internal party office, whether or not they amounted to a direct financial benefit to the minister concerned, and whether or not the minister had any control over them. There's some vagueness in Amabhungane's case, or at least there was until the oral argument commenced today, about whether or not the minister concerned had to have any direct knowledge of those donations, or more precisely, whether the minister only had to disclose the donations that they knew about, or whether they were required by the amendment to the code that Amabhungane seeks to go out and find out donations that they didn't know about. Now, my learned friend said in an answer to Justice Colopin that it wasn't his proposition that every single donation, whether the member knew about it or not, had to be disclosed. Well, we submit that that is a telling concession. If the obligation is only to disclose the donations that the minister knows about, then the obligation that Amabhungane argues for does not achieve the constitutional purpose in which the obligation is said to be grounded. The constitutional obligation is simply on the president to promote transparency, to make sure that the general public know who contributed to a particular minister's campaign. Now, if that is so, if that's the requirement, if transparency is the requirement, then how can the minister not be under an obligation to go and looking for campaigns that supported their their accession to a particular party office and the donations that were made to those campaigns. So if that's not the obligation contended for, then the constitutional purpose sought to be achieved in this case is simply not achieved. If the obligation, however, is for the minister only to disclose those donations they knew about, then the obligation is somewhat trivial and can be circumvented in precisely the way that Amabhungane complains about. The minister can simply choose not to know what was contributed to the campaigns for the internal party office and what and in that way avoid disclosure. So we have some difficulty with what exactly is being contended for. It seems to us if what is being contended for is an obligation to seek out campaigns that support a minister's accession to party office, then the obligation is far too onerous. If the obligation is to only disclose those donations that the minister knew about, then the obligation is somewhat trivial. Now, the central question, of course, is whether the code, whether that sort of obligation is necessarily implied by the Constitution and the Act. And we submit not. Our core submission is that the Ethics Act has left the president with a particular kind of policy choice. Either the president can enact the code to require full disclosure of a donation to any campaign to which a minister is linked, whether or not those donations constituted a benefit, or the president is entitled in terms of the Act to leave room for arrangements which seek to ensure that the minister never finds out, and so avoids a conflict of interest. Now, we submit that the provisions of the Executive Methods Ethics Act are consistent with either of these arrangements. The difficulty is that in attacking the code's failure to require absolute disclosure, what Amabhungane are effectively doing is attacking a policy decision left open by the Act, to allow arrangements that look a great deal like what the CR17 campaign sought to achieve in this case, an arm's length relationship between the candidate and the campaign for internal party office, whereby the campaign seeks to avoid a conflict of interest by not knowing about the donations that have been made to the particular campaign that supported them. In other words, the executive...
I'm very sorry to interrupt you, Mr. Wilson.
Yes.
My colleagues are uncharacteristically quiet, and I suspect they might have forgotten that you waived the 10-minute protection. Please continue.
Yes. Well, we submit, thank you, Justice Midlanger, we submit that the Executive Members Ethics Act leaves open the possibility that arm's length arrangements between a minister and their internal party campaign might be consistent with non-disclosure, at least to the minister, of donations to that campaign. And the president drafted the code so as to facilitate that possibility. It follows that the code does exactly what the Act requires it to do. And for that reason, the challenge to the code must fail. A challenge to the Act, which is not, of course, not before the court, would have to engage directly with a difficult set of questions about the desirability of disclosure on the one hand, and the wisdom of seeking to avoid conflicts of interest.
Sorry, Mr. Wilson, could I ask you this? You posit that the policy choice open to the president was to leave open the possibility of an arm's length relationship, and by doing so then to avoid the duty to disclose.
Yeah.
And in the narrow sense, that may well be so. But would you not say that the consequence of that may well undermine the whole objective of ensuring that the relationship between money and politics is not dealt with decisively? And so indeed, the failure to disclose there may well come back later where information comes into the public domain that indeed a donation was made to the campaign of a particular member of a political party who then came into office and who perhaps just incidentally and not linked to the donation awarded a contract in favor. Would that outcome not undermine the very objective of openness and transparency? And can it then be said that the president does indeed have that policy choice, or is that policy choice taken away from the president if one has regard to the objectives of both what the Constitution seeks to achieve and in particular the Ethics Act?
Yes, we readily accept that the objective of transparency that you put to me, Justice Colopin, may well be frustrated by the Executive Members Ethics Act. But the obligation to disclose that, to promote that transparency that the applicants in this case argue for, must be sourced primarily in the Executive Members Ethics Act, read, of course, in light of the values of the Constitution. And we submit that if there's a difficulty with the kinds of disclosures or non-disclosures that the code permits, then it is a difficulty to be grounded in, that is a difficulty to be found in the Act, and it's the Act that has to be challenged. When that challenge is made, then this court will be in a position to confront the complex questions about what kinds of transparency and disclosure are appropriate. And it may well be, we submit, it's not an argument we have to make, or it's not a horse we have to ride, but it may well be that a cogent argument can be made that the Executive Ethics Act is about avoiding conflicts of interest. One can avoid conflicts of interest altogether by sequestering a party political campaign, an internal party political campaign, from the candidate that holds government office completely, such that a conflict of interest doesn't arise because the candidate doesn't know what donations have been made to the internal party campaign. Now, if one looks at the Executive Members Ethics Act, that seems to be the textual, the purpose implied by the text and the underlying purpose of the Act, to avoid acts of bad faith, conflicts of interest, improper relationships, improper benefits, not disclosure of those things if they've already taken place or might have taken place, but the avoidance of those things altogether. Now, if we're right about that, then the Executive Members Ethics Act leaves open the possibility that the code could be drafted to enable precisely the arm's length relationship that Amabhungane criticizes. And that may be a legitimate way of promoting the absence of conflicts of interest, which is the entire purpose of the Act and the constitutional provision it gives effect to. It may or may not be, but we submit that that's the debate that has to be had. And the debate can only be had through a direct facial challenge to the Executive Ethics Act to more directly promote the kind of disclosure Amabhungane argues for, at the expense, perhaps, of the arm's length structures that seem to have been adopted on the facts of this case.
Mr. Wilson, that would give the Ethics Act quite a narrow remit and would almost seek to interpret it in a way that's disconnected from the broad constitutional imperative. So the Act in 2B, for example, speaks of prohibiting MECs from acting in a way that may compromise the credibility of their office or of the government. So it's not an individual thing. It's conduct that may impact on the government as a whole. And I go back to the policy choice, that may impact on the government as a whole. And so one interprets the Act purposefully as one would, then maybe the policy choice that you contend for may not be such an attractive argument if one has regard to the Act interpreted purposefully. Maybe restrictively, yes. Yeah.
Well, Justice Colopin, once you accept that there may be more than one way of ensuring that a minister acts in a way that is consistent with their office, or in other words, doesn't act in a way that is inconsistent with their office. One of those ways might involve the imposition of the substantial duty of disclosure that Amabhungane argues for, and another might be a kind of arm's length relationship between the campaign and the candidate, such that the candidate never finds out who's donated to their campaign. Once you accept, as we submit must be fairly obvious, that those are two ways of promoting that objective, then it becomes a problem with the Act. The Act doesn't prescribe a particular kind of disclosure, nor does it rule out ways of structuring political campaigns that avoid that disclosure having to be made by making sure that the MEC or the Minister of concerned never comes by the information to disclose. Which is why it's so important we submit about whether the obligation, to answer the question about whether the obligation being argued for is that the MEC and the Minister must go out and find out all the campaigns that have supported them and all the donors to those campaigns and then disclose those, or whether the Minister is under a narrower obligation just to disclose those they happen to know about. If the second, it's a far-reaching and onerous obligation, which seems to us to be not at all necessarily implied by the Executive Members Ethics Act. If the first, it's somewhat trivial and doesn't seem to promote the constitutional purposes that Amabhungane says it wants to promote, those of absolute transparency of all donations to a particular party campaign. So if you were to interpret, Justice Colopin, the Executive Members Ethics Act to require only the kinds of disclosure that Amabhungane argues for, then we would accept that the code is unconstitutional. But we submit that textually, and even read in light of the constitutional values it's meant to promote, it's not capable of that sort of narrow interpretation. And we would argue, in fact, that it's Amabhungane that wants the narrow interpretation, not the submissions of the amicus curiae. We say that there are many ways to prevent the kinds of conflicts of interest and corruption that the Executive Members Ethics Act seeks to prevent. Only one of those is the kind of far-reaching disclosure obligation that Amabhungane argues for. And in seeking to advance that actually it's only that kind of obligation that combats corruption effectively enough, what Amabhungane is doing is really challenging the Act rather than the code that was promulgated under it. So it's really a question of how you interpret the Act.
Mr. Wilson?
Yes.
Mr. Wilson?
Yes,
what is the, I just want to understand your argument. If you look at section 22C of the Ethics Act,
yes,
which says that the cabinet ministers and the deputy ministers must disclose all their financial interests when assuming office, and also any financial interest on an annual basis after assumption of office. You compare that to para 6 of the code.
Yes.
Is para 6, which then lists, it's almost like itemizes what must be disclosed. If you compare the two, is para 6 that is now of the code not narrowing down what is contained in section 22C of the Act?
Yes, well, it all depends on the construal you give to the words financial interests in the Act. If one accepts that financial interests encompass any donation to any campaign that is sympathetic to a particular candidate's succession to a party office, even ones that the candidate doesn't know about, even one that the candidate had no hand in setting up or arranging, even one the candidate that had no visible relationship with or no cognizable relationship with, then yes, of course, section 6 of the code narrows down what financial interests mean. And if you give that definition to financial interests in the Act, then my learned friend's case must succeed. But we submit with respect that that's putting too much weight on the words financial interest. A financial interest must be narrower than that. I have to confess that before I did this case, I thought the financial interests were simply stocks and shares. They may be that a particular person holds. There may even be, as Justice Untitled posits, the fact that one benefits from a trust, but one would have to stand to receive money from that trust. Financial interests may be capable of a much wider definition than that, but one that takes it so wide as to posit any donation to any campaign that is supportive of the particular candidate's succession to party office, we submit is just far too wide and far too onerous. But it seems to be the constitutional purpose that is being promoted in this case, because the purpose is transparency and nothing else. And as what we submit with respect, that the Executive Members Ethics Act requires a more supple, narrower, more nuanced idea of what disclosure is, that has to be balanced against the other objectives of the Act, avoiding conflicts of interest, avoiding improper conduct. And we say that disclosure is only one tool, or it seems to us on the text of the Act, the suggestion is disclosure is only one tool to ensure those other goods. And once you accept that disclosure is only one tool to ensure those other goods, that certain kinds of arrangements that may entail non-disclosure can also promote the absence of conflicts of interest, then one has to accept that the debate is not about the code, it's about the Act.
So when you say one should actually challenge the Act and not the code, what would that, in what respect, what is wrong with the Act? Because it's of this breadth, because it's wide, or what?
The challenge, well, the challenge that Amabhungane might bring to the Act, and it's certainly not my place to try and tell them or put words in their mouth. But the challenge they might bring to the Act is to say something like this, is to actually make the criticism that they do in paragraph 55 of their heads of argument, that the Act permits a situation in which a minister is careful to avoid a conflict of interest by setting up a separate campaign and by avoiding playing any direct role in that campaign, by avoiding knowing what donations are made to that campaign, and thereby by avoiding a duty of disclosure. That is plainly, we submit, something that is permitted by the Executive Members Ethics Act. And if that is unconstitutional, then the Executive Members Ethics Act is unconstitutional, not the code. But we submit that in leaving room for those kinds of arm's length relationships, the code as promulgated by the President does exactly what the Executive Ethics Act says, Executive Members Ethics Act says it must do. If that is wrong, then the problem is with the Act and not with the code. This isn't just a technical point. It's a point about the breadth of the debate. If one is going to make a constitutional choice between absolute disclosure of these donations, an absolute duty to disclose these donations, and mechanisms and arrangements that might avoid that duty, but for proper and wholesome purposes, such as avoiding conflicts of interest, then that is the debate that has to be had in the context of a challenge to the Act. And it's a debate that best serves the development of constitutional law, not trying to suggest that the Executive Members Ethics Act imposes an obligation which it plainly doesn't.
You also mentioned in your submissions that in fact the Political Party Funding Act is appropriate. There is no need to declare the code invalid. Yeah. One can have regard to the Political Party Funding Act and PIA. Yeah. Can you just elaborate on that submission, please?
Well, as I understand the written submissions made on behalf of the amicus, which of course I didn't settle, but I accept that I'm completely bound by. The point is this, that the issue of disclosure of party political, of donations to internal party campaigns could be dealt with through a wide variety of mechanisms. It could be dealt with through an amendment to PIA. It could be dealt with through an amendment to the Party Political Funding Act. And the virtue of dealing with the issue raised by the applicants in that way would be to place the obligation to disclose not on the minister concerned, who may or may not know about them, may or may not be in a duty, under a duty to go and find out about the donations, but on the campaigns themselves. One can readily imagine an amendment to the Party Political Funding Act that says it's not just political parties that have all of these duties of disclosure and all of these regulations about how they can and can't receive money, but internal party campaigns where they are legally separate from the minister or the member of the party themselves must also disclose. So what I understand the heads of argument to be saying is again that trying to force that sort of disclosure obligation on the minister first of all, doesn't accord with the content of the Executive Members Ethics Act, but is secondly better achieved through a legislative intervention that places the obligation on the campaign and not on the individual concerned.
Wilson, can I follow up on that and ask?
Yes.
I understand your submission to be that this would require amendments to those acts. As I read the written submissions, and I understand you didn't settle them, but as I read the written submissions for the amici, it suggested that the legislation as it stands, without a need for amendment, would meet Amabhungane's concerns in respect of the Party Political Funding Act and PIA. Now, I wanted to ask, where in the PPFA would one find such an accommodation? And secondly, how would PIA assist, given its laborious procedures and the enormity of potential requests that would have to be made in terms of that act?
Well, first of all, as I read the Party Political Funding Act, Justice Midgett, it seems to me that the Act places no obligations on internal party campaigns where they've been set up separately from the candidate concerned. And so, however one reads the written submissions that were delivered to the court, I think the Party Funding Act would require, the kind of disclosure obligation argued for by the applicants would require an amendment to the Party Funding Act. It would also require, in order to ensure automatic disclosure of the nature my learned friend argued for, he made the very cogent point that actually PIA requires applications, not automatic disclosure. In order to require that, PIA would also have to be amended. He's quite right. The point being made in the amicus's submissions, as far as I can tell, is that if there is this obligation, this far-reaching obligation of disclosure, then one achieves it through a challenge. One could achieve the obligation, or one could achieve the operationalization of the obligation through a challenge to the Party Political Funding Act for being under-inclusive. My learned friend, Mr. Salukazana, tells me that in paragraph 96 of our heads of argument, we say that the Party Political Funding Act, the Political Party Funding Act may be amended to ensure that it provides for disclosure from everyone that competes in internal political party position campaigns. So Mr. Salukazana, who no doubt drafted these heads, or at least did the first draft, and who was in a better position to interpret them perhaps than I am, accords, or the note he passes to me accords with my submission. The point we make isn't that the acts as they stand are sufficient to meet the applicant's requirements. They would have to be amended.
Mr. Wilson, that act, as the long title and the preamble says, and its very name deals with political party funding, and that was the subject of my vote counts too.
Yes.
It doesn't seem to me to have in mind what we are dealing with here, generally speaking.
No, the way of achieving the disclosure obligation the applicants argued for would be to challenge it as under-inclusive, and that challenge would stand or fall on its merits. One could also do what we submit ought to have been done in this case and challenge the Executive Members Ethics Act, because it doesn't require the kinds of disclosure that the applicants say are required in terms of the code.
I have a related question under the act, under this act, the PPFA, but also one on subsidiarity. Let me do the PPFA one first.
Yeah.
What is your comment on section 10? The same question I asked Mr. Budlander. Is there any room there for addressing the question before us? Because it is a particularly difficult section, all subsections 10, 1, 2, and 3, to understand what it actually means. I don't know if you have a better understanding of it than I do.
It will come as no surprise to the court that we've been poring over this during the adjournment. It seems to me that it's necessary to read section 10 of the Act with the donation, with the definition of donation in section 1 of the Act. Donation in section 1 of the Act includes a donation in kind, but does not include a membership fee of the political party or any levy imposed by the party or its elected representatives, or any funds provided to the political party by the National Assembly and provincial legislatures, respectively, in terms of the Constitution. So donation seems to me to mean a private donation to a political party. And section 10 seems to require simply that where there is such a donation to a political party, it may not be made to a member other than for the purposes of that political party. And the member may not receive the donation other than on behalf of the party. So it doesn't seem to address at all the difficulty of donations that may constitute a financial interest of an individual candidate. Doesn't seem to address at all the difficulty of donations to internal party campaigns. So I'm not sure it's helpful at all. I think I'm probably with my learned friend on that point.
Then the last question from my side on subsidiarity. Now, again, I know you were not in the case from the start, but do you subsist in the submission made in the written submissions that on subsidiarity, the applicants, Amabhungane, wrongly challenged the code under this constitution and not under the Ethics Act? Because it seems to me, in a proper reading of the papers, that they always challenged the code, the provisions of the code under those impugned provisions, or those provisions of the Constitution, namely 1972 and 96, and also 195, but also under the Ethics Act.
Yes. The applicant's challenge, I think, properly construed, is against the president's failure to take reasonable steps to promote the obligation, the disclosure obligation that they argue for. So they say you get to where they want to go by focusing solely on the president's conduct in promulgating the code and testing it against the obligation in section 7.2 to respect, protect, and promote and fulfill the rights in the Bill of Rights. Of course, in this case, the right to vote, as interpreted in my vote counts. However one labels the answer to that given in the heads of argument, or indeed in my submissions, whether it's a subsidiarity point or some other kind of point, the point is very simple. It's simply that those obligations can only be placed on the minister if the act itself can be interpreted to place those obligations on the minister. So if the act, the president, that obligation could only have been on the president when he promulgated the code. If the act can be interpreted to put that obligation on him, you can't apply section 7.2 directly to the president's conduct under the act without interpreting the words of the Act and divining what limits they placed on the president's conduct, or what appropriate policy choices they gave the president when he promulgated the code. And that's the criticism in the heads of argument. That's the criticism we persist with, that if one reads the Act in light of the various constitutional values that it is meant to promote, it isn't just that the Act is there to promote disclosure, finish and clear. It's there to promote a wide range of values, all of which ultimately promote executive ethics. And an example of one of those values is keeping cabinet members free of conflicts of interest. And this case provides some factual fodder for the proposition that there may be a tension between placing the minister under an obligation to disclose donations to an internal party campaign and the kinds of arm's length relationships that seek to avoid the minister having to disclose because he doesn't know and doesn't want to know what donations have been made. And once one accepts that that tension is inherent in the Act, it doesn't matter what level of interpretive gymnastics you try. You have to challenge the Act. You have to say that insofar as the Executive Members Ethics Act permits the kinds of arm's length relationships that the applicants criticize in their heads of argument, then it must be unconstitutional. Whether it is or it isn't is not really the point. The question is how one frames the debate before this court in order to ensure that the right kinds of obligations are declared and the president is placed under the right kinds of obligations when he promulgates the code. And the difficulty with the applicant's submissions is they completely bypass the very real possibility that an arm's length blind trust type arrangement, which avoids a conflict of interest by avoiding the minister from acquiring knowledge and therefore avoids the duty of disclosure that seems to be argued for, may be a perfectly appropriate way of promoting executive members' ethics. And to the extent that the Act permits it, the Act needs to be assessed constitutionally on those terms. One can't just criticize the president's decision to promulgate the code.
Yes, thank you, Mr. Wilson. Thank you, Mr. Mojanga.
Mr. Wilson, I wonder if I could take you back to the question of financial interest.
Yes.
As I understand your interpretation of financial interest, you have in mind that a campaign may be separately constituted over which the candidate has no control and indeed is ignorant as to who donates to it. And that would not give rise to a financial interest within the meaning of that term in Section 2. Broadly, is that your interpretation?
That's correct.
Yes. I'm wanting to raise with you this problem, if it is a problem, which is that when a candidate accepts the benefits of a campaign thus structured, they actually do have a financial interest in the campaign. You see, it seems rather artificial when construing legislation of this kind, given that it concerns ethics at the crossroads of political power and money, that one could avoid a notion of financial interest, or rather constrain it, by saying, well, as long as the formal structuring is separate, we don't need to be concerned with the benefits that flow. And it's rather, if I may use a private law analogy, it's rather like a stipulatio alteri. You may not be party to the contract, but you accept the benefits and therefore you have a financial interest. And so I'm wondering whether your construction of financial interest isn't, in the context of this legislation at least, too formalistic to really capture what that term means.
Yes, the point goes a little bit further than simply saying, well, if one structures things this way, then the benefit received by the candidate will never be financial, will never be a financial interest. It depends what the arm's length campaign does. So if, for example, an organization that I know nothing about is set up tomorrow and seeks to promote my candidature to the ANC's Treasurer Generalship, raises money from sources that I have no knowledge of, and pursues objectives that are ultimately meant to ensure that I win the election, but that I have no control of and I have had no say in, such as putting posters up around a particular neighborhood. There's no sense in which I've derived a financial benefit from that kind of conduct. But the obligation, as I understand the applicants to argue for it, would require me to seek out the donors to that campaign and disclose them. If, however, I set up a campaign that I intended to fund directly my efforts to become the ANC Treasurer General, the situation might be different. So the point is simply that one has to interpret financial interests in the context of the practical situations that are likely to arise in these arm's length types of cases. And it doesn't.
Well, I mean, isn't that raising? I mean, the question as to what arm's length really means. So assuming I declare my candidature, and I say, but from this point on, I want you, my campaign manager, to handle the entire way in which fundraising is done to support my campaign. That may look arm's length, but in fact, it's nothing of the kind. You're simply saying, well, I'm delegating to somebody else everything as to how to fund my campaign, but I wish it to be done, and it is done in my interests, and hence I am the beneficiary. If through no conceivable agency on my part, and I don't mean agency in a formal legal sense, but just gratuitously out there, there's somebody who happens to like me and chooses to do things that might be beneficial, but I don't will them to do so, and I have no knowledge of what they're doing, that might be different.
Yeah, yes, of course.
You accept that distinction?
I absolutely accept that distinction, but the difficulty is the obligation that the applicants argue for doesn't obviously accept that kind of distinction. It doesn't seem to me to be clear how far the obligation to disclose that the applicants argue for goes. My learned friend at one point in his argument said, well, my clients would like total transparency of all supportive campaigns. He then went on to say, in fairness to him, that's not what he argues for here.
Yeah, but wouldn't it follow that at least on the construction of financial interest that I think you would recognize of the kind we've been debating, the code falls short as it is now structured? Well,
it would depend on the precise nature of the arrangement. If it was the arrangement that you posit to me, Justice Untitled, that arm's length wasn't really arm's length at all, it was maybe index finger length.
I think it's not just index finger length. It is within a political party, you have supporters who say, leave the campaign funding and its structuring to us, and the candidate then marches off to do other things. It may look arm's length, but you are still the beneficiary.
In those circumstances, then what that campaign does may become something in which the candidate is financially interested.
Yes, and to that extent, at least, I think the logic of your argument would suggest that the code is deficient as it now stands.
We accept that if financial interests bear that meaning, then the code is deficient insofar as it fails to provide for their disclosure. Yes.
Yes.
But there's a wide. Sorry, Justice Untitled.
No, please go ahead. Please go ahead.
But there are a wider range of possible structures and arrangements at play here. There could be an entirely separate corporate entity set up by my friends in the party that had provisions that prevented me from participating in that entity or knowing anything about it.
You see, I think the participation is not the critical point. It's whether you have your supporters and you have some connection, such as to make you the beneficiary of what is done to promote your candidature.
Yes, but then the question is, what duty of disclosure do I have? And if the requirement is that I must disclose, you would have to accept that financial interest was intended to require the use of the word financial interest in the Act, read in the context of the Act as a whole, was intended to require disclosure of the financial contributions to entirely separate campaigns that were set up in order to construct a wall of ignorance between the candidate and the campaign.
Isn't that the constitutional interpretation?
Well,
isn't that broadly what My Vote Counts is about? That we have to be very concerned.
Yeah,
we have to be. Don't worry about the My Vote Counts concern some other matters, but in terms of the broad constitutional concerns that we have, we are concerned about the way in which money can corrupt politics and politics corrupts money.
Yes, but the difficulty is in what context and what the relationships are between the particular players. The context of My Vote Counts Too matters because it was about a voter's right to know who contributed to a particular party political campaign. There was no possible countervailing interest, at least none that was recognized in any legislation, that a political party would have in not knowing who had contributed to it. And there was no balancing of values to happen. A voter was entitled to know who had contributed to a particular party in order to exercise a meaningful right to vote. Here, the considerations are different. The question isn't transparency almost for transparency's sake in order to allow informed decisions. Here, the Executive Members Ethics Act seeks to create a situation in which improper relationships are avoided. Those improper relationships, such as conflicts of interests, improper benefits, may be avoided in a variety of different ways. And if one accepts that the Executive Members Ethics Act is meant to accommodate the kind of arm's length relationships we've been talking about, that might well affect how one interprets financial interests and whether financial interests interpreted purposively in light of the Act and the Constitution can bear the meaning necessary to get the applicants home on the case that they make.
Mr. Wilson, can I just, in the interests of time, just take you to one other question around conflict of interest and what it may mean in the context of this legislation?
Yeah.
You've made the submission that if the office holder doesn't know who contributed, how can they practically be in a conflict because they don't know what the conflict of interest and duty is? I'm wondering, though, about this situation in which, although the office holder is ignorant of who donated to their campaign, there are intermediaries who come to seek to influence the office holder who do know, and then use their proximity, say, to a minister or the president, to, as it were, indirectly bring about the conflict of interest. Do you see what I mean? In other words, the persons who were involved in the campaign come to the minister, and the minister doesn't know that they come on behalf of the people who contributed, but nevertheless, objectively speaking, what is happening is that the campaign donations are being used to influence the policy choices of the person who is then appointed.
Well, I wonder whether that means that there is a conflict of interest, though. The conflict.
I think that's the force of the question I'm asking. Is that a conflict of interest, or is it so much in the borderland that you would have to have an amendment to the Act to capture that species of problem?
I'm tempted to plumb for the second proposition that you put to me, Justice Untitled. Certainly, if those intermediaries said, "Well, hang on, the person who sent has contributed to your campaign, and you expect a bit of payback," obviously a conflict of interest. But it seems to me that the essence of a conflict of interest is that a particular person has two conflicting interests, and in order to have two conflicting interests, you've got to know about them both. And it seems to me that we're dealing with a different species of corruption in the example that you posit to me, Justice Untitled, that may well require an effort to address it, maybe through an amendment to this Act, maybe through an amendment to another Act. But it's a problem with the structure of the Act and not the code, we would submit.
Yes, thank you. Thank you, Justice Madlanga.
Mr. Wilson. Mr. Budlander referred to shortcomings in the code.
Yes.
He said one of the shortcomings is that in section 2C of the Act, it refers to any financial interest. And the shortcoming is that the code doesn't refer to any. Initially, I was attracted to that argument, but I'm having some doubts now, and perhaps you can help me. If we look at section 2C, sub 2.
Yes.
It says any financial interest acquired after the assumption of office. We go down, it says, and other benefits of a material nature received by them.
Yes.
As may be determined in the Code of Ethics.
Yeah.
So it says the code must deal with that, and the code must deal with the financial interest and any other benefits of a material nature. And doesn't the code do that in 6.4, where the code says the nature and source of any other benefit of a material nature must be disclosed?
Yes.
So where's the conflict? Where's the shortcoming in the code?
Well, we respectfully don't see one, Justice Theron, and we would perhaps push the point a little bit further and say that in deciding and interpreting and construing what financial interests are for the purposes of the Act, one has regard to the second part of section 22C2, that what is meant is not some indirect political benefit that may or may not accrue from a party political campaign set up separately from the candidate, but more concrete financial benefits of that nature.
But where do we find that, Mr. Wilson, that what is meant is not a political benefit, but a more concrete benefit, as you put it?
Well, I mean, the use of the phrase financial interest itself suggests a degree of concrete pecuniary benefit. In fact, my learned friend even said even suggested that financial interests might mean pecuniary benefit, or might encompass pecuniary benefit. All I'm saying, I don't know where the line is, to be honest, Justice Theron. All I'm saying is the phrase financial interest doesn't obviously encompass the whole range of benefits that a candidate would accrue from a separately constituted campaign to support their ascent to party office.
But
if it does, then the applicants are right. If it doesn't, then there's a problem.
I'm sorry to interrupt you, Mr. Wilson.
Sorry, I was interrupting you, Justice Theron.
Yeah. Isn't financial interests and other benefits of a material nature separate concepts that we're talking about? And they separated in the Act, and they're also separated in the code.
Yes.
If you look at 2C sub 2, it says any financial interests, and it lists some, and it says, and other benefits of a material nature.
Yes.
And to make my point further, if you look at section 6 of the code, it says financial interest to be disclosed.
Yes.
And it seems to deal in 6.1.2.3 with types of financial interest. But then again, we have 6.4, although it's under the subheading of financial interest, it says any other benefit of a material nature.
Yes. I accept on the language of section 22C2 that benefits of a material nature must be a subset of financial interests. Financial interest must encompass something more than benefits of a material nature. The case we make doesn't depend on them being the same thing. What it depends on is that one may receive other benefits from separately constituted political campaigns set up to allow a particular person to succeed to a party office, which go beyond what can reasonably be said to be a financial interest.
Now, aren't we constrained to some extent by what we found in Public Protector, Mr. Wilson, where we found that donations in inter-party political campaigns are not per se disclosable under the code?
Yes.
And wouldn't it go further that those types of donations, therefore, that would be the finding in Public Protector, do not constitute any other benefit of a material nature?
Well, what I understand Public Protector to say is that a financial benefit to a particular person is a financial benefit no matter where it comes from. So if a party political campaign, if a political campaign for internal party office provided a direct financial benefit to the candidate that it seeks to support, then that benefit would be disclosable under the code as it stands. There would have the area, the lacuna, the area that isn't covered on my learned friend's argument is anything that isn't a direct financial benefit, but nonetheless constitutes some sort of interest or some sort of contribution to the candidate generally. The question is, how far does the Act go in defining or telling us what those benefits might be? And remember,
I'm not sure, Mr. Wilson, that we need to go as far as direct benefit. The code says any other benefit.
Yes.
And in Public Protector, we found that financial interests, as it appears in the Act, doesn't include per se inter-party political campaigns.
No.
Isn't that the end of the matter? Isn't that the end of the matter?
Well, we submit that it isn't. The nature of the financial interest the meaning that you would have to give to the word financial interest in the Act would have to.
Haven't we already given a meaning to financial interest?
No, you said what it isn't. You haven't said what it is. In Public Protector, you said not this. You didn't give a positive definition, and so that's why it's not the end of the matter. If one accepts that the Act and the Constitution implies the kind of wide-ranging disclosure that the applicants consent.
I'm sorry to interrupt you, but isn't that exactly why Amabhungane are before us?
Yes.
They say the deficiency in the Act is because of what we said it's not. Isn't that so?
Yes, but then their argument requires you to accept that financial interests, that every time anybody donates to any campaign that is generally supportive of a particular person's succession to party office, by virtue of that donation, the candidate acquires a financial interest that has to be disclosed in terms of the Act. And the code is deficient because it doesn't require the disclosure of that interest. If they are right, then the code must fall for that reason. We question whether, if you read the concept of a financial interest in the context of an act of the act of as a whole, it cannot bear that wide meaning, because other parts of the Act suggest that those kinds of disclosure obligations may not be appropriate in seeking to avoid conflicts of interest.
You referred to the example, Mr. Wilson, of an entity who perhaps wanted to support your campaign, and they buy posters and they put these posters up. If that entity had not done that, used their financial resources to put posters up, you might not have gained the benefit of that, the exposure which that brought to you. Isn't that a benefit?
It's certainly a benefit. I don't know whether it's a financial interest under the Act, though. That's a question of interpretation for this court to confront.
So are you saying that benefit, as listed in section 6.4 of the code, must be a benefit that is a financial interest?
It's got to be a benefit that is capable of being part of what a financial interest is, but the two aren't coterminous because of the language of the Act. The idea of financial interest goes broader than benefits of a material nature. The code defines benefits of a material nature. It doesn't obviously, and I speak subject to correction, define what a financial interest is. But in order to be said to be within the boundaries of the Act, the benefits defined in the code would have to count as financial interests. They just wouldn't be the only things that counted as financial interests. We're dealing with the other side of the penumbra. What we're suggesting is that not every single benefit that an internal party campaign gives to a particular candidate may be classified as a financial interest. But one has to accept that if one is going to find that disclosure of the nature that the applicants contend for is required, because they say any donation to any campaign that supported that particular candidate, even if it's at an arm's length entity. And we submit that the Act doesn't obviously or necessarily bear that meaning. And because it doesn't obviously or necessarily bear that meaning, and because it seeks to promote other ways of avoiding conflicts of interest that don't depend on disclosure, then the problem, if there is one, is with the Act and not with the code.
Yes, I won't repeat the proposition that I've made to you earlier about section 2C2, which seems to separate financial interest and other benefits.
Yes, but one may include the other, is our point, Justice Turan. It's not that they're completely different things. It's that on the interpretation, it doesn't seem to me to be obvious that section 2C2 means that financial interests and other benefits are completely different things. They may overlap. One may be a species of the other.
Yes. Now, I'm not sure that the argument that you advance about financial interest and interpreting it restrictively accords with the instruction in section 39.2 as to how we should read legislation, or with some of the decisions. For example, in Ollie versus Marstorp, how interest there, financial interest, was interpreted. What do you say about that? And conflict of interest?
Well, I want to try and avoid repeating myself, Justice Strawn, but the point is simply this. If there is more than one way to avoid improper relationships, corruption, conflicts of interest, that are, if there's more than one method to avoid all of those things, which is evident from the Act, some of them may depend on disclosure, and some of them may depend, for good reasons, from protecting the minister from the obligation to disclose, then the court is not seized with a straightforward obligation to interpret financial interests or any other part of the Act in a way such as to promote greater transparency. There are other interests and other mechanisms at play, such as the need to ensure, for example, if this is legitimate, to ensure that the kinds of arm's length arrangements that the applicants criticize can be maintained. If one accepts that that could possibly be, or may appropriately be, a mechanism through which the objects of the Executive Members Ethics Act may be promoted, and the President may perfectly appropriately, in promulgating the code, have left those possibilities and those mechanisms open, then the problem is with the Act. It's because the Act in and of itself doesn't just promote absolute transparency of the nature that the applicants suggest. It promotes a wide range of other matters of executive ethics, which may or may not include a duty to disclose. So the Act has to be challenged and not the code. That's really the submission. So the proposition you put to me, Justice Strawn, would be correct if the only game in town was, how do we promote the Executive Members Ethics Act to ensure more transparency? And to ensure that the obligation that the applicants argue for can be imposed. We submit that that isn't obviously the only game in town. That these other mechanisms, these other arm's length relationships that avoid for good reason disclosure and transparency may be appropriate ways of promoting the purposes of the Act.
Thank you, Mr. Wilson. Thank you, Justice Blanca.
Thank you, Justice Strawn.
Thank you, Mrs. Mr. Wilson, we are way beyond your end point. How much more time do you want?
If I can just consult my note and take an instruction from my learned friend. I think that, albeit not in the order that I had set them out in my note, we've covered the various submissions that we want to make. Our aim, of course, is to be of assistance to the court, and if there's anything else that we can address, then we're very happy to do so. Otherwise, those are our submissions, Justice Madlanga.
Let me at this point, Mr. Wilson, and maybe there will be mention in the judgment as well. Thank you and Mr. Salukazana, and also counsel, senior counsel who settled the written submissions. Thank you most profusely for having come to the assistance of the court at its request. Thank you very much.
To have helped us, thanks enough, Justice Madlanga. Thank you very much.
Thank you. Yes, Mr. Butlender.
Yes, thank you very, very much, Justice Madlanga. Justice Madlanga, we've listened carefully to the address by our learned friend, and we only have a few discrete points that we wish to raise. There are 4. The first is, I just want to spend a moment on what the current practical effect of the code is. And then I will explain, secondly, why this is a problem. And then thirdly, I will explain how to solve the problem in light of the concessions that our learned friend has made, and in doing so, deal with the debate about the Act versus the code. And finally, I will deal with the question of remedy, because it seems with respect that our learned friend has confused debates about how to fix the problem, which is about versus whether there is a problem to start with. But let me begin at the beginning. Let's assume that there is a campaign, that I want to run a campaign to be elected, as unlikely as it may be, as president of the ANC. And let's assume that my campaign is styled exactly along the lines of CR17. There's a separate entity, it's not my agent, I'm not controlling it, etc. Subject to one thing, just to avoid any doubt. At the end of every day, the people at the end who are running my campaign send a note. And the note says, "Dear Mr. Budlander, the following people have donated to the campaign. Kind regards, your fundraisers." Nothing more. They don't, I'm not involved, I'm not running it, it's not my agent. They're just telling me, just as a matter of interest, these are the ones. Under the current code, would those donations have to be disclosed? The answer is no. And the fact that the answer is no is made clear by this court's judgment, and including the paragraph which I read to you earlier about paragraph 81. It's not about knowledge or lack of knowledge. So the current code produces a situation where millions of rand can be raised by my campaign or by a campaign to elect me as president of the ANC. And where I find out on a daily basis who has put in how much money, and I would not have to disclose any of that, even if I am a minister, even if I am the current deputy president, and even if I'm president. That is the effect of the current code. So all this theoretical debate that our learned friend raises about blind trust arrangements at arm's length and possible ways of, it doesn't matter for present purposes. The current code produces the possibility of millions of rand being sent to the campaigns to elect senior members of the executive in circumstances where they know exactly who has donated and exactly how much, and without that ever being disclosed. That's the effect of the current code. Now we ask the second question, is that a problem? Well, of course it's a problem. It's a problem because this court said so in My Vote Counts 2. This court said in My Vote Counts 2, and I apologize for reading a passage, but it's critically important. This court said, "The commitment to build a united and democratic South Africa and to improve the quality of life of citizens can be honored by public office bearers, can only be honored by public office bearers whose character or willpower is unencumbered." Then the next sentence, "Only when there is a risk of being exposed for receiving funding from dubious characters or entities that could influence them negatively for the advancement of personal or sectoral interests, would all political parties and independent candidates be constrained to steer clear of such funders and be free to honor their declared priorities and constitutional obligations. And that risk of disclosure, would be enabled by a regime that compels disclosure of information on the private funding of political players." So when my learned friend says, well, there's not only one game in town, disclosure as a way of preventing corruption. There are other games in town like arm's length blind trusts. But with respect, that's not our law. Our law in light of My Vote Counts says, only when there is a risk of disclosure will this problem be dealt with. There's only one game in town. When you're dealing with the influence of money flowing to people who know about it, in my example, there's only one game in town. It's the game identified in paragraph 42 of this court's judgment in My Vote Counts 2, and which is reaffirmed in paragraph 47 of this court's judgment in My Vote Counts 2, where this court says, that was a debate about whether you had to hold the information. And the court said the loophole or leeway not to hold or not to preserve, or not to hold or not to preserve information, and the consequential non-disclosure of information relating to private funding or quantifiable support in hand constitutes fertile ground for undermining or even subverting the real will of the people. If the door is left open to potentially or actually compromise political parties or independent candidates to be voted into office, then government birthed by such flawed political players could hardly be described as based on the will of the people. So there is no question that it's a problem, because My Vote Counts 2 says so. So we now know that the present code, as presently applied in practical terms and as interpreted by this court in Public Protector, gives rise to a constitutional problem. No question. That raises the third question. How do we solve the problem? Well, my learned friend concedes quite properly that you can't solve the problem via the triple PFA. He accepts that the triple PFA in its present form does not solve the problem and would need to be amended. And my learned friend accepts quite properly that PIA in its present form does not solve the problem and that PIA would have to be amended. So what does he give us? He gives us a single argument, an argument of an extraordinarily technical nature, which says we should have attacked the Act instead of the Code. Well, let's just examine that argument. That is an argument which says that there is a problem with the Act and that the Act somehow does not indicate whether disclosure is the appropriate way of dealing with these matters. Disclosure or the other game in town, the knowledge issue or the blinds trust issue. But that, with respect, is quite wrong. Because when you go and read the Act, if we read section 2 of the Act, what it says is, 2.1 says that the Code has to have rules aimed at promoting open, democratic, and accountable government. Fine. 2.2 says that there must be provisions about good faith, best interests of government. Fine. 2.2a. 2.2b says it must include provisions preventing various things, including people exposing themselves to any situation involving the risk of conflict and acting in a way that might compromise credibility or integrity. Fine. Thus far, I can accept that the Act doesn't speak about whether disclosure is the solution or whether there might be other ways of solving this problem. But 2.2c is absolutely unequivocal. It says the Code of Ethics must require cabinet members to disclose. What must they disclose? All financial interests acquired after their assumption of office. Now, they could have put a full stop there, but they didn't. Sorry, not all. Any financial interests acquired after their assumption of office. They don't put a full stop. They use the word including to make clear how broad financial interests is, including any gifts, sponsored travel, pensions, hospitality, and other benefits of a material nature received by them. So where I agree with my learned friend is that there's no sharp line between benefits of a material nature on the one hand and financial interests on the other. I agree, he's right on that, because the wording says it's any financial interests acquired, and then it lists examples: gifts, sponsored travel, pensions, hospitality, and other benefits of a material nature. But what is being done there is to demonstrate it's any financial interests of any kind, even an unusual kind like pensions, hospitality, benefits of a material nature received by them. When Parliament did the Act, they got it right. They said you must cast the net as broadly as possible. And that's why the questions put by Justice Unterhalter about the broad definition of financial interests with respect are correct. Because that's what Parliament was doing. So when you look at the Act, there is no constitutional problem with the Act. The constitutional problem arises because when the Code is enacted, instead of providing greater clarity and help to people to determine what to disclose, it inadvertently narrows it. It inadvertently narrows it to do something that was not anticipated. It narrows the definition of financial interests. And suddenly, as a consequence, party donations slip through the crack, even though they are obviously a financial benefit or benefits of a material nature, and even though you might know who's giving them to you. And that's the constitutional problem, that the Code is narrow compared to the Act, which is broad. And so should we be challenging the Act? Well, of course not, because the Act doesn't cause the problem. And we would lose a challenge to the Act on this basis, because we would be told, I mean, can you imagine, if I could just ask the question rhetorically, can you imagine if I was in this court saying, but 2.2c is too narrow? This court would be laughing at me, because they would be saying, but Mr. Budlander, we all know about Hyundai. It's been in place for 25 years. You've got to interpret the words financial interest in light of 39.2 and in light of what this court said in Glenister. Would you please stop wasting our time? That's what would have happened if we had challenged the Act. Because there is no problem with the Act when you read its text and you read it in the constitutional context as 39.2. The problem comes in with the Code. So what is the practical effect of the Code? Question one. The practical effect is that the president or the deputy president or the premier can receive millions of rand in support, or a campaign to support them can receive millions of rand, even with them knowing who's donating on a daily basis, and it will not be disclosed. Is there a problem? Of course there's a problem, because My Vote Counts 2 said so. And how does one solve the problem? One solves the problem by fixing the code, not the act, and you fix the code by challenging the code, which is what we've done here.
Mr. Budlander.
Yes.
Sorry
Yes,
to
sir.
interrupt you. Doesn't the problem in the code arise because of the way, as a result of how this court interpreted the code in Public Protector?
Justice Theron, I accept that if this court had interpreted the code in a different way, then there may be no constitutional problem. So to that extent, you're correct. So if this court had said, for example, actually material benefit under 6.4 is not a personal benefit, and it includes political party donations, then yes, I agree. Then this challenge wouldn't, the problem wouldn't have arisen, and the challenge wouldn't have arisen. And you will recall that Amabhungane's challenge was always conditional. But the fact is, Justice Theron, that this court did interpret it in that way. And it held, and I must accept that it's correct, this court held that the code doesn't include those political party donations. What that means is that as a matter of law, this code does not require the disclosure of those donations. Now, whether that was right or wrong or indifferent is besides the point. As a matter of law, the binding authority of this court now commands that every MP who asks for advice, should I disclose this, will be told by his lawyer, no, you don't have to, because this code does not require it. How do you know? Because the ConCourt told us so. So Justice Theron, you are quite right with respect that the problem arises in a sense from this court's judgment. I don't want to say it's caused by this court's judgment, but it arises from the code as interpreted by this court. But that doesn't change the fact that what that means is now what we do is we assess that code as interpreted by this court against the Act and the Constitution. And when you do that, you hit the My Votes 2 problem, and therefore it's unconstitutional. And Justice Theron, just to finish the point, let me say, debates about whether this court was right or wrong are beside the point, because we must all accept that this court was right in its interpretation of the code, and that was the only issue before it, because this court expressly avoided the constitutional challenge and expressly sent it back to the High Court to be determined. So that's why I made the point earlier. It was a very unusual case, that because of the unfortunate way in which the full bench dealt with the matter first time round, this court was presented with a bifurcated case, a debate about the interpretation on the one hand, that's in the PP case, and a debate about the constitutionality in the Amabhungane case. And this court understandably said, we're not going to be first and final instance on that second question. We're going to interpret the code alone and send the constitutional attack back to the High Court. That's fine. But what that means is that now the constitutional challenge has to be determined, and it has to be determined in light of this court's judgment, which holds that the code is narrow, not broad. And because the code is narrow, not broad, the constitutional problem arises, and the code therefore falls to be struck down to that extent.
Thank you, Mr. Budlander.
Thank you, Justice Theron. That then leads to the last question, Justice Madlanga, and that's the question of remedy. Because my learned friend made various points about, well, we can't decide what our case is and how much disclosure do we want. Let me be unambiguous. My client, for whom I act, wants as much disclosure as possible. My client contends that disclosure is the only way of dealing with these things, and that the approach of sequestering or blind trusts or whatever is ineffective and unrealistic. That is my client's position. It's always been its position. I suspect it always will be its position. But that's not the debate for today. The debate for today doesn't have to get into whether disclosure is always the case, because as I've demonstrated in my practical example, this is an easy case. Take the example of the Premier who has the campaign set up separately, doesn't control it, and receives the daily updates. Anglo American donated R1 million to you. Billiton donated R1 million to you. The Guptas donated R1 million to you. He receives those daily updates. He would not have to disclose. Once that is so, the code is unconstitutional. And the court doesn't have to determine in this case the outer reaches of disclosure. All the court has to say is that the code as it stands is unconstitutional. it's declared invalid, and it will be the president who will have to fix whether it's going to be all donations disclosed, some of them, or others. And if he gets it wrong, I have little doubt that my client will challenge it again, and he will have to explain why, and there might be another case, or somebody else will. But that's not today's debate. The famous, I think it was Cass Sunstein who said, one case at a time. I hope it was Sunstein. One case at a time. Today's case is about this code, which is patently unconstitutional. What might happen in the future should not and need not be prejudged by this court. And that's why, Justice Collopin, in answer to your question, I said, we're not asking for this court to make a determination that every disclosure is necessarily disclosed, that every donation is necessarily disclosable, even if it was to a blind trust and nobody knew. That's not a concession, and I need to be clear on it. We're not making any concessions on that score. We're just saying that's not the issue for determination today. And my client specifically, and I need to say this unambiguously, stands by its position that all of these donations, all donations should be disclosed, and that there shouldn't be a sequestering approach. But we don't have to get there today, because today, as this court has repeatedly made clear in its remedy cases, you strike down and you leave it for the decision maker to fix. And if the decision maker fixes in a manner that fixes it properly, then that's it. And if the decision maker doesn't, then there will be another challenge with properly prepared papers focusing on the properly nuanced issue, and the court will decide it at that point. Justice Madlanga, those are our submissions. It occurs to me that the one issue that we didn't deal with is the question of costs. We did not ask for costs against our learned friend, Mr. Wilson, of course. That would seem to add insult to injury. But there is the debate about whether the president should pay the costs. We respectfully submit, and our understanding of the law is that in confirmation proceedings, the decision maker is required to pay the costs, even if they don't oppose. And if I could refer the court to the judgment in Levenstein, the Frankel matter, in which that issue arose. So as I understand the position in our law, where you have to come to court to declare something invalid because of, and you've got to come to this court because of confirmation proceedings, then you are entitled to your costs, even if ultimately the minister, or in this case, the president, doesn't oppose. And so we submit we are entitled to our costs, including the costs of 2 counsel.
Thank you, Mr. Badlander, and thank you to both sets of counsel. Judgment is reserved. Court adjourned.
Today's proceedings have concluded. The host will now